No, it's not.
The
gold one? The gold one is not.
Oh,
The
yeah.
gold one, that is also not. Neither. No.
Okay, I'll leave it here for a little bit if it's still here after today. Yeah, so Emily's will be right. Yes, please.
You might be outside, but these are.
That's good stuff. So deep. Usually it's definitely.
Oh.
Major discord.
Unless we have actually.
Oh, yeah. That's good.
Not today,
Like,
not this exact round.
so it's just.
Yeah. Oh, yes, no, I don't. Except for all shoes.
No, already.
What's your name?
But it's a little bit high.
Maybe just like us. And I was texting Thomas and saying,
Stop it.
in 4 ways. One, two. John, put your hands on. Okay. My eyes are watering. Sorry.
That's my deck. But it.
Yeah, like John. That's why. I did do it over there. That's why I didn't. That one.
How are you?
That is good. How's the price? I miss Audrey. Last after she did my makeup every single day. I was like a drag queen. But I missed her. Yeah, we're gonna have them tomorrow.
Oh.
Where she go? Ready, Jenna? This is strange for sure. Oh my gosh, imagine if I signed this form and it was just like beautiful, perfect signature. It's perfect. A doctor. Want to see mine? Not that you have it already. That's a good one. No, the end was not good.
Thanks. It's.
I do. Yes. No. Her. No.
Or things that is the good ones are obvious.
It's a way, but not way.
Did you just start this live stream? You can go on it. Okay, so that's cool. Yeah. So, but I've done it. So the other side.
Yeah,
And
yeah.
so, yeah, same stuff.
I know. It's funny. I already know. Exactly.
Just this. Yeah, over here is fine. The best angle. Great.
All right, thank you. Call the case. Court will come to order and call the case of Justice Carbo versus Shooting Star Gun Club LLC, case number 23CB 2023. The court will first hear oral argument and decide the plaintiff's pending motion in limine regarding the claim under the Responsible Firearm Sales Practice Act. Counsel for Mr. Carbo, will you please state your appearance?
Yes, Your Honor. Good afternoon, Your Honor. My name is Thomas Staub, counsel for the plaintiff, Justice Carbo. May my co-counsel please introduce themselves?
Absolutely.
Good afternoon, Your Honor. John Williamson.
Good afternoon, Your Honor. Jenna Ahuja.
And Your Honor, may I invite the court's attention to our timekeeper?
Yes.
Good afternoon, Your Honor. Fiona Martinez.
With that, we're ready to proceed.
Thank you. And counsel for the defense, will you please make your appearances for the record as well?
Yes, Your Honor. My name is Kavin Sivakumari, and we represent Shooting Star Gun Club. Can my co-counsel introduce themselves?
Yes.
Good afternoon, Your Honor. My name is Luciano Fernandez.
Good afternoon. My name is Kadozi. And could we introduce our timekeeper as well?
Yes.
Good afternoon, Your Honor. My name is Brianna Toza.
Thank you. All right, so I'm going to just go through the procedure here for the oral argument very briefly. The parties will each have a total of 8 minutes to present their argument, with the possibility of an additional 2 minutes in courtesy time that the court may permit in its discretion. Counsel will each have 45 seconds to present the argument without interruption, after which time I may or may not ask questions. Counsel for Carbo will, yes, correct. Mr. Carbo is playing. If I need to make sure I'm oriented just as much as you guys. So counsel for Carbo will argue first, and the jury is constructively absent from this argument, so you should address me and not the jurors at this time. Timekeepers, are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Thank you. So when the first 45 seconds after each side's argument is up, we can both stand quietly and prominently display your time cards. Do not call time aloud unless I do not see or acknowledge you. When time expires for the main argument, please stand and say out loud, stop. Do you understand and agree to abide by these rules?
Yes, Your Honor.
You. And then I may also permit the courtesy time up to 2 minutes each side per argument. And then immediately upon the expiration of the courtesy time, you're required to stand and call out time. Do you understand and agree by this rule?
Yes, Your Honor.
Counsel for Carbo, you may reserve up to 3 minutes of time for rebuttal argument. How much time will you reserve?
Yes, Your Honor. I'd like to reserve 2 minutes for my rebuttal.
Counsel, you reserve 2 minutes for your rebuttal. Please stand and notify me after 6 minutes then, and you leave 2 minutes for counsel.
Yes, Your Honor.
You. All right, counsel for Mr. Carbo, you may proceed.
Good afternoon, Your Honor. Jenna Ahuja for the plaintiff. Gun violence is a prominent issue in our society. Just as a bartender puts the public in danger by allowing an intoxicated person to drive a vehicle, so a retailer puts the public in danger by selling a gun to somebody unfit to use it. The defense has challenged the constitutionality of the Responsible Firearms Sales Practices Act under the Second Amendment, an act which not only limits the sale of arms to people who are fit to safely use them, but also provides individuals harmed by gun violence with a private right of action and an expanded scope of review. Today, we ask you to find this law constitutional as applied to today's case for two reasons. First, the Second Amendment does not cover the conduct that the act prohibits. And second, even if it did, historical tradition supports reasonable restrictions on the selling of firearms. First, the Second Amendment does not cover the conduct that the act prohibits. The Second Amendment protects the right of the people to keep and bear arms. Nowhere in the Second Amendment is the right to sell guns listed.
But isn't that kind of a logical extension? You have to buy the guns from somewhere, and I know there's arguments that you can purchase pieces from different places and stuff like that, but we don't want people doing that either. So how do you get around that factual issue?
Of course, Your Honor, we don't actually dispute that there is an implicit right to buy in the Second Amendment, but the defense's as-applied challenge in this case is on the basis the defendant's rights were violated. And Your Honor, the defendant is a company, Shooting Star Gun. So the defense has the burden to prove that there's an implicit right to sell under the Second Amendment. And Your Honor, it's our contention that there's not. The ability to sell is only relevant insofar as it affects the right to buy. Even if Your Honor were to hold that this law did violate the rights of buyers, the defense would not have standing to bring that claim. The Second Amendment gives individuals the right to keep and bear arms, with the guarantee that that right will not be infringed upon by the state or federal government.
So we know that the Supreme Court decided Bruin very recently, and how do you think that the decision in that case affects the outcome here? Because it looks to me like the rule that was basically struck down in New York is almost the same as the statute is.
Yes, Your Honor, it's actually our contention that it's not. The may issue laws in Bruin allowed for individuals, licensing officials, to decide whether or not somebody had shown cause or sustainability for that license. Now, the distinction there is that required buyers to show a special need for self-defense. Your Honor, our case does not require buyers to show any special need. It simply asks sellers to determine whether somebody is fit.
But isn't that worse?
No, Your Honor, because it's not the subjectivity of this law that's at issue today, because Bruin didn't actually entirely invalidate subjectivity. If we look at the concealed carry law in Connecticut and Rhode Island, they both had a suitable person standard, which required the licensing official to determine whether somebody's conduct has shown them to be lacking the essential character or temperament necessary to be entrusted with a weapon. Your Honor, that is a subjective standard, but the court in Bruin found that because it didn't require buyers to show a special need in order to invoke their Second Amendment rights, that it was not unconstitutional. It's our contention that sellers are always asked to determine whether somebody will be safe with a firearm. They always have the right to refuse service to individuals. This act is actually just holding them accountable to sell to people who are safe.
But what seller would actually want to do that? I want to sell guns and make money. What do I care who I'm selling it to? And especially if the Constitution says, you know, we can't have a law that infringes on that. All the better for my business, right? How would you respond to that?
Well, that's exactly why this law is important in this case, because if sellers aren't held accountable for who they sell to, they may well sell to people who will be unfit or who will cause danger to the general public.
Does Mr. Carbo or the employee in this case, I mean, regardless, don't they have a right to defend themselves? And doesn't this infringe on that right?
Are you referring to Justice Carbo and Drew Cantrell's right?
Correct, or anybody's right, I guess.
Yes, Your Honor, law-abiding responsible citizens do have a right to self-defense. But Your Honor, because the defense is bringing the challenge in this case, we only have to focus on Shooting Star's rights. We can decide whether or not Justice Carbo and Drew Cantrell actually were law-abiding responsible citizens if you grant our motion and allow the second cause of action in trial today. But the defense's challenge is on the nature of Shooting Star's rights being violated, Shooting Star being the company. So we have to focus on the right to sell. Additionally, Your Honor, this is in line with historical tradition because the purpose of this law is to prevent people who might carry arms in a dangerous manner from owning them in the first place. Your Honor, when we look at historical tradition from the early 1300s to the late 1800s, there's one common thread that's woven throughout, and that's that reasonable restrictions on the unsafe bearing of arms that prevent disturbance of the peace do not violate the Second Amendment of the Constitution.
It seems to me, though, and I'm bound by the precedent of the Supreme Court, obviously, that in the last, say, 10 years, 15 years, we have just, or the Supreme Court has struck down regulation after regulation after regulation on the basis that those didn't exist. So how do you distinguish that?
Yes, Your Honor, it's our contention that similar laws to this do exist. For example, we have to look at, Bruin states that we have to look at two things in determining historical analog. The reason why it affects someone's Second Amendment rights and the manner in which it goes about doing them. Your Honor, may I briefly answer your question?
Yes.
As far as the reason for that, like I just said, there's 4 different states in colonial America that all prohibited the bearing of arms in a way that spreads terror among the public. Therefore, the purpose of this act is in line with historical tradition. And as for the manner of this act, Your Honor, I've shown through the Connecticut statute and the Rhode Island statute that even if there is some subjectivity in this act, the idea of preventing unsafe people from carrying firearms is in line with historical tradition. It's for these reasons that we respectfully request that you grant our motion.
Thank
you.
Counsel for the defense?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Your Honor, and may it please the court. My name is Mitsuko Fernandez, and I represent Shooting Star Gun Club in this case. Today, the defense asks that you deny plaintiff's motion in limine for a second cause of action under statute 2007, as it is unconstitutional on the Second Amendment. On May 28, 2022, Shooting Star sold a handgun to the plaintiff and subsequently entrusted said handgun to Drew Cantrell, an employee, to instruct a safety course. The plaintiff has just alleged that the sale of this firearm is in violation of the act. Now, Your Honor, today the defense is challenging the constitutionality of the act because it gives retailers undue discretion based on subjective factors. And in doing so, it fails to meet this nation's historical firearm standards. And Your Honor,
Don't you think it is reasonable and there's some presumption that the legislature enacts constitutional laws? Don't you think it's reasonable that we ask a gun store to not sell guns to people who are unfit? Isn't that an important public safety goal?
of course, Your Honor, it's incredibly important to manage gun violence, especially in that way. However, it's also important that we ask retailers to do this in a way that is reasonable and in a way that is constitutional. And we're asking retailers to do this in a way that is unconstitutional based on the criteria of the act. Now, Your Honor, the act asks retailers to assess a gun buyer for their fitness to own, use, or possess a firearm based on a totality of the circumstances test. And this totality of the circumstances test encompasses 9 vague, subjective factors. And these factors are not, they're not given with guidelines to the retailers on how to assess gun buyers based on those factors. For example, if we look to criteria for fitness within the act, how should a retailer assess, let's say, maturity, which is one of the factors in the act? Should they base it off their conversations with the gun buyer? How should a retailer assess intelligence? Should a gun buyer have to have obtained a post-secondary education? Should they have to have achieved a minimum GPA? How should a retailer factor in prior conviction to their assessment of a gun buyer? If a gun buyer has just a misdemeanor, are they denied a gun? Does it have to be a felony before they're denied a gun?
So are you saying that it's, if the legislature had said, if you have a 3.0 GPA and if you have a felony, then you can't buy a gun. Or excuse me, I guess it would be, if you have a 3.0 GPA and you don't have a felony, then you can buy a gun. If you don't have a 3.0 GPA and you do have a felony, then you can't buy a gun. And so they put parameters on all of those things. Would it be your contention that the statute is then constitutional?
Well, Your Honor, that's one of the parts of what would make the statute constitutional. In this case, if they had given specific parameters like you mentioned, then that would make it more constitutional, as that would be more objective. However, retailers are non-government officials. They wouldn't have access to information that you just spoke of. So they wouldn't be able to make proper assessments of gun buyers if they needed to obtain these informations based on just their
It
context.
strikes me though that your argument is less about the constitutionality of it and more about the practicalities of doing this, right? Is it practical for the store owner to go through and figure out what somebody's GPA is? How does that affect whether or not it's constitutional?
Well, Your Honor, the act essentially turns a constitutional right into a privilege because the subjectivity of the act allows retailers to put their own prejudices and biases over the factors of the act. Essentially, the act allows a retailer who is a non-government official to regulate whether a citizen is able to or not able to exercise their constitutional right. And the fact that a retailer could even make an improper assessment based on these factors is exactly what makes it unconstitutional. And Your Honor, Heller held that the Second Amendment is an important right that applies to all individuals in the United States. And it's unreasonable for a non-government official to be regulating the act in a manner, to be regulating a constitutional right in a manner such as that. Additionally, if we look to Bruin held that the Second Amendment must held to, or restrictions on the Second Amendment must be held to standards that are definite, narrow, and objective, and not requiring the appraisal of facts or the exercise of knowledge and the formation of an opinion. And that is exactly what the act is doing in this case. Now, Your Honor, I want to respond to an argument that the plaintiff mentioned. They mentioned that firearms retail does not fall under the protections of the Second Amendment. But they also mentioned that buying firearms falls under the protections of the Second Amendment. That makes sense because if an individual isn't able to buy arms, then they're not able to exercise their right to carry arms. But what happens if retailers are not able to sell arms? If retailers aren't able to sell arms, then individuals aren't able to buy. And in that way, Your Honor, the firearms retail falls under the protections of the Second Amendment.
I believe their argument, right, was that the Second Amendment is directed at the person who's keeping and bearing arms. Was that your understanding of what their argument was?
Yes, Your Honor, that is my understanding as
Okay.
well.
And so you would say that in order for that Second Amendment to be, it also needs to encompass the retailers as well.
Yes, it does need to encompass retailers because retailers are the ones providing the guns to individuals, then they fall within the Second Amendment because if they're not able to provide these guns, then individuals are not able to obtain the guns.
Is there any historical analog that, under Bruin, I have to look at history and look at whether or not there are historical analogs for the law at issue? So was there the same law or a similar law that existed back in, at some period in history? Are there any of those in this case?
Well, Your Honor, it's the defense's contention today that there is no relevant historical analog to the act. Now, the plaintiff mentioned the laws from the 1300s to the 1800s that I think regulate or try to prevent and disallow the disturbance of the peace. But Your Honor, that only addresses one aspect of how and why these restrictions burden an individual's rights to the Second Amendment. The act and these restrictions may have a similar why aspect. They want to prevent gun violence. They want to prevent abuse of firearms. However, the act restricts the Second Amendment in a completely different way than these restrictions restrict the Second Amendment.
How so?
The act restricts it based on a retailer not being able to, or a retailer not selling a gun to someone who wants to sell a gun. And these restrictions place restrict the individual themselves, and they restrict them by punishing them after they had caused harm and not before they may have caused. Your Honor, with those reasons in mind, we ask that you deny plaintiff's motion in the minute.
Thank you. Thank you.
Rebuttal, Your Honor.
Yes.
May I proceed?
You know.
I want to address a couple of things that opposing counsel mentioned in their argument. First, they argued that Heller says that the Second Amendment applies to every single individual in the United States. But Your Honor, Heller makes it very clear that the Second Amendment right is afforded to law-abiding, responsible citizens. And it's our contention that by the nature of this act, it does not prevent those individuals from exercising their rights. They also said, and I wrote it down, that it, quote, allows retailers to put their prejudice into their decision. But Your Honor, that's not an issue with this act, that's an issue with the retailer. Even if there was an act that had very, very objective standards, such as only criminal records and background checks, sellers still have the ability to decide based on prejudice whether they want to sell to somebody. They always have the right to refuse service to individuals. And so if they're going to prejudice themselves against.
But not if the statute says, if you have the 3.0 GPA, you can buy a gun.
Well,
Or you shall be allowed to buy a gun, right? I mean, that kind of controls the outcome there.
yes, Your Honor, to an extent, but because these are all private entities, they all have signs in them saying that they reserve the right to refuse service to anybody. And so if they're going to refuse service based on prejudice, that's not something that this act is asking them to do. It's something that they do out of their own accord. Additionally, they argued that sellers can't make this proper assessment because they don't have the same resources as the government. But Your Honor, the key words in this act are reasonably known. A seller is only held accountable if they could have reasonably known that the person they're selling to would be unfit with that weapon. And that means that reasonably with the resources provided to them, not with resources that they wouldn't be able to achieve. If a seller would have had no way of knowing that somebody would act in a reckless way with a firearm, they're not held accountable for selling to them. It's for these reasons that we respectfully request that you grant our motion and allow the act in trial today. Thank you.
Thank you. I'm just going to take 2 minutes to do my own scoring here, and then I will decide the motion. All right, so this time I am going to grant the motion, and I'm going to allow the plaintiff to proceed on their secondary finding that the statute is constitutional in this case. In particular, I think that it is does set reasonable and measurable standards for a retailer to determine what the parameters are that they should be issuing. Parameters are that they should be using to determine whether or not to sell a gun. So I will find it constitutional, and we will proceed on that theory. Okay. I don't know if you need just 30 seconds to get yourself organized or anything like that.
Your Honor, we just have a few housekeeping matters to address before we actually start with opening statements.
Just make sure I'm keeping up with you there.
No worries.
And then it also does look like that given that I've granted the motion, exhibits 16, 17, and 18 may be entered into evidence by either party, of course, subject to the Empyrean Evidence Ordinance. Okay, so we'll move to the housekeeping matters now.
Yes, Your Honor. First, we ask to sequester all witnesses with the exception of party representatives. In our case, it would be Justice Carbo under Rule 615.
Yes, that's great.
Next, we ask Your Honor's preference for movement about the courtroom and well during statements and examinations.
Yes. Yes.
Would you like us to ask before entering the well or in approaching opposing counsel?
No, I think it's gonna be more efficient if we can just keep things flowing. That's fine.
Yes, Your Honor. Lastly, I have here an intent to offer character evidence form that was signed by both plaintiff and defense counsel. We, as the plaintiff, do intend to offer evidence of Drew Cantrell's recklessness, and in turn, the defense made notice of their intent to not offer evidence of the plaintiff's witnesses' characters for truthfulness or untruthfulness.
Is that a correct statement?
Yes, Your Honor.
Oh, thank you. So the court will accept that stipulation.
And would Your Honor like this?
Yes, please. Thank you.
And with that, Your Honor, we're ready to proceed.
Thank you. Counsel for Shooting Star, housekeeping matters?
Yes, Your Honor. We'd just like to ask your preference on objection etiquette. Would you prefer that we stand up and immediately state our grounds, or stand up, wait to be acknowledged by the court, and then stand?
I think I'd prefer if you just wait to be acknowledged, just so that we can ensure that nobody's talking over each other.
Yes, Your Honor. Finally, the defense would like to make notice of the court's attention that under stipulation 13, Jackie Staub, our expert, has been already tendered as an expert in firearms mechanics and analysis. In addition to that, Your Honor, the defense will be using demonstratives over the course of the trial. We conferred with opposing counsel and they've consented to this.
And is that correct?
Yes, Your Honor.
Then you're welcome to do that.
Your Honor, with that, the defense is ready.
Thank you. So just from a practical standpoint, we'll need to take just a moment after each examination, cross-examination, to record our own, so that, you know, we will be typing, I think, as we go along. Hopefully that's not a distraction to everybody, but we'll need that time there as well. And once we have everybody's scores submitted as we move along, then I will invite the next person up to wherever we might be. So with that, we will begin with opening statements. Counsel for the plaintiff.
Yes, Your Honor.
Thank you.
May it please the court. They put a gun in the wrong hands. It's May 28th, 2022, and a woman named Justice Carbo has decided to buy a gun from Shooting Star Gun Club. There's just one problem. She doesn't know anything about guns. So she decides to trust Shooting Star Gun Club. Trust that they know what they're doing. Trust that their employees are going to keep her safe. By 11:30 that very same morning, Justice Carbo is writhing on the ground with a bullet lodged in her leg, carelessly shot by an employee with a history of flagrantly ignoring gun safety. Which is why we brought suit against Shooting Star for their negligence and violation of state law in putting a gun in the wrong hands. For putting a gun in the hands of their employee, Drew Cantrell. Now, we have the burden to prove more likely than not that Shooting Star was negligent in the retention and promotion of Drew Cantrell, and that this directly led to my client's injury. Now, we also have the burden to prove that Shooting Star violated Empyrean State Law 2007, the Responsible Firearms Sales Practices Act, which states that no person may entrust a weapon to any individual they know is unfit to operate. In this case, the Shooting Star entrusting a gun into the hands of their employee, Drew Cantrell. Now, we'll meet that burden by proving two facts. First, Drew Cantrell demonstrated that she was unfit to be made a safety instructor. And second, that same irresponsibility is what led her to shoot my client in the leg. Now, first you'll hear that Drew Cantrell demonstrated that she was unfit to be made a safety instructor. But Roz Hernandez will take the stand and tell you how she witnessed an angry Drew Cantrell suddenly pull a gun on a coworker in the heat of an argument, violating the most basic rule of gun safety. Now you hear that after this, she wasn't fired. Rather, a Shooting Star promoted her to safety instructor, where she'd have a gun in her hands almost every day. You hear just 3 months later, Miss Cantrell again violated a basic rule of gun safety, right in front of Shooting Star's owner. No firing, no demotion, not even suspension. A second will prove that negligent retention and promotion of Drew Cantrell directly caused my client's injury. Now, Justice Carver will take the stand and tell you how exactly what happened on May 28th when she was shot. And Dr. Morgan Judd, an expert in firearm safety, will analyze those events. Now, most important out of all their testimony will be the fact that Drew Cantrell, she didn't release her hand on the gun after losing control of it. Now, members of the jury, that may seem counterintuitive. Why not try to maintain your grip on a falling gun? It's something that Dr. Judd will explain to you as being the most dangerous safety violation that a person can engage in. And when Drew Cantrell tried to keep on gripping that gun, it caused the trigger to be pulled a second time and the gun to refire. Members of the jury, my client put her safety, her life, into the hands of Drew Cantrell. When Shooting Star put a gun in her hands, my client's safety meant nothing to them. Which is why we'll ask to find Shooting Star liable for Justice Carver's injuries and in violation of the Responsible Firearms Sales Practice Act. Because they put a gun in the wrong hands. Thank you.
Thank you. Counsel for the defense.
Yes, sir.
Thank you.
Your Honor, opposing counsel, members of the jury, may it please the court. It's not our job to stop the unpredictable. In our lives, there are things we can control and things we can't. Sometimes we'll have that forecasted sunny day turn into a rainy one, or the occasional subway delay. But at a gun range, unpredictable actions have dire consequences. Now, Shooting Star is a company that's been a benefactor to their community for over 3 decades. Every person that enters their store becomes a member of their community, regardless of their interest in guns. In order to keep the members of their community safe, Shooting Star holds themselves to the highest level of safety standards. But no amount of precaution can account for spontaneous or unpredictable actions. Members of the jury, today's case involves an unpredictable action, an unpredictable decision, one that was outside of Drew Cantrell's control. When Justice Scarborough crossed the line into danger, they caused the May 28th accident. Members of the jury, it was not Drew Cantrell's job to stop the unpredictable. Now, the plaintiff has brought 2 charges of action against the defense. The first being the negligent hiring, retention, and supervision of Drew Cantrell, and the second being the reckless entrustment or reckless sale of firearm to Drew Cantrell. Now, let's go through the charges. In order to prove their first cause of action, they must prove to you that Drew Cantrell was unfit or became unfit for the work they were hired for. They must also prove to you that Drew Cantrell's employment was the direct and proximate cause of Justice Carbo's injury. This means they must prove to you that Drew Cantrell's employment was the factor, not a factor, but the factor that caused Justice Carbo's injury. Now, in order to prove their second cause of action, they must prove to you that Shooting Star recklessly entrusted a gun to Drew Cantrell and that they should not have been able to handle that firearm. Now, it's important for you to note that the burden of proof lies solely with this bench. Any failure to prove beyond a preponderance of the evidence, meaning more likely than not, that all the elements of the charges are true, should result in a not liable verdict. Now, in order to refute these claims made by the plaintiff, the defense will call 3 witnesses to the stand. We'll first call Drew Cantrell, the firearm safety instructor that actually led the demonstration for Justice Carbo. They'll tell you that even before they applied for Shooting Star, they already had 2 decades of firearm experience. They'll tell you that on May 28th, they placed Justice Carbo behind them and away from the line of fire. What they'll also tell you, members of the jury, is that they faced an unexpected interference. And that unexpected interference was Justice Carbo. When Justice Carbo moved closer to Drew Cantrell, they caused May 28th accident. Now, we'll also call Jackie Staub to the stand, an expert in firearm mechanics. They'll tell you how Drew Cantrell, she has all the necessary requirements to be teaching that course and handling the firearm. They'll also tell you that that specific Glock 22 that was used during the training course, it had a sensitive trigger. And that sensitive trigger is what caused the second shot to go off. But members of the jury, you won't have to take Miss Cantrell's word for what happened on May 28th. We'll call Avery Nguyen, a regular at Shooting Star Gun Club. She'll tell you how Shooting Star always adhered to legal requirements. Even though they knew she was an expert and knew how to handle firearms, they always offered her a complimentary training course. But more importantly, members of the jury, they'll testify that as Drew Cantrell stopped to fire their firearm, Justice Carbo was dangerously crowded. Now, members of the jury, after seeing all the evidence and hearing all the testimonies, the defense is confident that there's only one verdict you can reach. And that verdict is not liable. And although the plaintiff has the burden of proof in this case, we're confident that we'll show you 2 things. We'll show you that Drew Cantrell is a competent employee who followed all industry standards on May 20th. We'll show you that what Justice Carbo did was unpredictable. Members of the jury, it was not Drew Cantrell's job to stop the unpredictable. It's for these reasons that we ask that you find Shooting Star not liable. Thank you.
Okay, so we will now proceed with the plaintiff's case. I believe the special instruction is that you will be calling Justice Carbo first to the stand, so we will go with that.
Yes, Your Honor. The plaintiff calls Justice Carbo to the witness stand.
Thank you.
May I proceed?
You may.
Good afternoon. Please introduce yourself to the members of the jury.
Hello, my name is Carbo.
What do you do for a living, Ms. Carbo?
I run a nonprofit organization. It's called Imperial Against Gun Violence. If you couldn't tell, we advocate against gun violence.
Well, how is it that you came to work for a nonprofit organization that addresses gun violence?
Well, unfortunately, I was shot in the leg.
Where did this injury take place?
We were shooting star gun clubs.
Why were you at a gun club?
Well, I feel safe in my own home. I mean, it was robbed 3 times, so I decided to get a gun for self-defense.
So did you end up purchasing a gun from Shooting Star?
Yeah, I did. It was the Glock 22.
Your Honor, I'm showing this witness what's in evidence as Exhibit 1. Ms. Carbo, do you know what this is?
Yes, that is the gun I bought.
And do you remember who you purchased this gun from?
Yeah, Skylar Coleman, he's the owner of Shooting Star Gun Club.
So did you leave with the gun right after you bought it?
Oh, no, I need to make sure that I knew how to use this gun. Safety is my priority, so I made sure that I was gonna get a safety course lesson, which I later did get.
Did Ms. Coleman teach the safety lesson?
No, it was an employee to control.
So where did Ms. Cantrell teach the lesson from?
We went down to the gun range and I had my safety course lesson at stall 11.
So let's get into the lesson itself. How did Ms. Cantrell start the lesson?
Well, she just started saying basic things about the gun. Never put your finger on the trigger. Just basic rules.
What did she do next?
She then started teaching us how to actually shoot and fire the gun.
Now, before she actually fired the gun, did she have you stand in a specific position in relation to her?
Yeah, I was to the right from her, a couple feet away.
Your Honor, the witness could step down to physically demonstrate where she and Ms. Cantrell were standing on May 28th.
Yes.
So, Ms. Carbo, if I'm standing where you were asked to stand, where was Ms. Cantrell in relation to you?
Yeah, so control was about right here.
What did you see Ms. Cantrell do?
Well, she had the gun in her hand, and before she shot the first shot, she made a sudden movement, fired the first shot, and just seconds after, she hit my left arm and then put the gun down at my leg, and I was shot.
Counselor, I don't want to ruin your flow, but I also don't want too much testimony from her up there, so.
Yes,
You
Your Honor.
indicated she was just showing where she's going to be at, but if she can return to the stand after.
Yes, Your Honor.
Thank
You can return to your seat, Ms. Carbo. Your Honor, let the record reflect that this witness positioned herself about a foot and a half away from me and held her hands up at shoulder height, made a sudden movement, and then pointed her hand at my left.
Yes.
Ms. Carbo, could you tell the members of the jury what happened when that second shot was fired?
Yeah. There was just so much blood. And I was in excruciating pain. I was shot in the leg. I couldn't believe it. I was just purely in shock. It just hurt so much.
Ms. Carbo, I want to be clear about something. When you saw Drew Cantrell flinch, fire the gun, and then point the gun towards you, did you see her let go of that gun before the second shot was fired?
No, they never let go of the gun before the second shot was fired.
Thank you, Ms. Carbo. Your Honor, nothing further.
Thank you. Cross?
Yes, Your Honor. Good afternoon, Ms. Carbo. I want to start by talking about whether Ms. Coleman did her job. You first went to Shooting Star on May 14th, 2022, is that correct?
Yes, that is correct.
And while you were there, Miss Coleman helped you out, right?
Yeah, one of those some basic things about guns.
In fact, she spent over an hour with you.
Yeah, she went over a couple things about guns for self-defense.
She went over safe gun handling and storage with you, right?
Yeah, briefly.
She made recommendations about the best guns for self-defense.
Yeah, she recommended the Boston too.
She described what paperwork that you would need to complete.
Yeah, it was this government form to fill out.
And finally, she recommended a beginner gun, right? She recommended a Glock 22.
Yes.
Now, before you left on May 14th, you filled out a government form, right?
Yes.
You had to confirm that you didn't have a criminal history.
Yeah, basic things.
And then you returned to Shooting Star on May 28th, is that right?
Yes.
And again, you had to fill out another government form.
Yeah, it was the same one. I had to recertify the information correctly.
And before giving you the gun, Miss Coleman ran a background check on you.
Yeah, I assume so.
Now I'd like to talk about whether Drew Cantrell did their job. Drew Cantrell gave you the firearm safety course, right?
Yeah, before I left, I asked Coleman if I was in the safety course lesson, which I did end up taking.
That's a yes to my question. And Miss Cantrell started this safety course by laying down basic gun safety rules. Is that right?
Yeah, basic things, like I said, don't put your finger in it, stuff like that.
And while doing this, they demonstrated each rule with the handgun.
Yeah, they did.
And prior to shooting the gun, they put on safety equipment, right?
Yes,
They put on goggles and earplugs.
that is-
And then they positioned you and Nick Allred, right?
yes, I was to the right of control.
Your Honor, let the record reflect that I'm approaching opposing counsel this with a copy of Exhibit 2G.
Yes,
Would you like a copy, Your Honor?
sure.
Ms. Carbo, you recognize this exhibit, right?
Yes, I do.
It's a picture of stall 11 where you took the course.
Correct.
Those are accurate labels of where everyone was standing during the incident.
Yeah, they are.
So this is a true and accurate copy of the exhibit. Your Honor, the defense would like to submit Exhibit 2G in the evidence.
Any objection
None, Your Honor.
will be admitted.
So you were standing at a red X, right, Ms. Carbo?
Yes, that's correct.
So you were behind Ms. Cantrell, right?
Yeah, a little bit.
You were completely outside her line of fire.
Yes, I was just to the right.
Your Honor, the record reflects that. I'm approaching counsel with a copy of Exhibit 2H. Would you like a copy, Your Honor?
Sure.
You recognize this exhibit, right, Ms. Carbo?
Yes, I do.
This is a picture of the stall after you got shot, right?
Yes,
To do an accurate copy,
it is.
Your Honor, the defense would like to submit the exhibit in the evidence.
Any objection?
None, Your Honor.
It will be admitted.
Your Honor, permission to set about a demonstrative.
Go ahead.
Can you?
Permission to rearrange so I can see.
Ms. Carbo, you just testified that your blood was right here, right?
Yes,
So it was just inside stall 11, is that correct?
that is correct.
You also testified that you were standing at this red X, right?
Yeah.
So you were outside and behind stall 11.
Yeah, around there.
All right, now, Ms. Carbo, I want to talk to you about something that you mentioned on the direct examination. You mentioned that Ms. Cantrell made a flinch or a movement while firing the gun. Is that correct?
Yeah, before they shot the first shot, I saw the sudden movement.
Now, Ms. Carbo, you're a gun novice, right?
I'm completely new to guns.
So you don't know anything about guns.
No, not really.
And you don't know what movement is normal when shooting a gun.
I'm not an expert, but I did see control make a movement before the
Right,
first
but you wouldn't be able to identify whether that movement is usual, right?
shot. Not exactly, I'm not sure, but I do know that they moved.
So you wouldn't be able to tell if that movement was recoil, right?
It was before the first shot, so
You wouldn't be able to tell if that movement is the usual movement when a person shoots a gun, is that correct?
I'm not completely sure, like I said, not necessarily an expert, but it did move before the first shot.
Thank you, Ms. Carbo, no further questions. Permission to take it on.
Yes, unless they would like to direct.
No, Your Honor.
Can you redirect?
Yes, Your Honor.
Go ahead.
Ms. Carbo, opposing counsel just asked you about the flinch that you saw before Ms. Cantrell fired the first shot. Just to make it clear for the members of the jury, when did you see Ms. Cantrell flinch?
It was before any of the bullets were fired, the first shot.
Thank you, Ms. Carbo. Your Honor, nothing further.
Anything from the defense?
No request, Your Honor.
Thank you. You may step down. I believe at this time, we'll give us a moment to. Next witness.
Yes, Your Honor, the plaintiff calls Roz Hernandez to the witness stand. May I proceed?
You may.
Good afternoon. Please introduce yourself to the members of the jury. Hi, I'm Roz Hernandez. Where are you from, Miss Hernandez? I'm a local. I've lived in Imperial all my life in the New Hoboken area. Do you know Skylar Coleman? Yes, I know Sky. What do you want to know about her? Let's start with how do you know Skylar Coleman? Where do I even begin? So I first met Sky when we became business partners. She basically made me who I am today. Are you saying you own a business with Skylar Coleman? Well, I own a business next door to Sky. So, I mean, it's kind of like we're business partners, business buddies, maybe. Ms. Hernandez, you mentioned you own a business. Could you tell us what it is?
Yes, so when Sky opened her business, Shooting Star Gun Club, I was inspired. So I opened my business, Fallen Star Laser Tag Club. It's basically like we're in the same line of work.
I want to ask you a couple of questions about Miss Coleman's business, Shooting Star Gun Club. Have you been there?
Have I been there? I practically live there. Okay, so I've got to confess, I'm not much of a real gun person. Sorry, Sky, but I go to the cafe there all the time.
Has Miss Coleman ever talked to you about the business?
Of course, I am Sky's business buddy.
How many times would you say she's talked to you about it?
Fine. I'm Sky's really busy.
Well, the one time she talked to you, what did she say?
Yeah, so we were talking about Sky's new marketing strategy. I asked Sky what her goal was, and she said she's just looking to put guns in the hands of every Imperian citizen. Genius!
Well, I want to talk to you about guns in particular. Did you ever see guns in the hands of Shooting Star's employees?
Well, it's a gun shop, so yeah, sweetie, I have.
Well, I'm going to need to ask you about one of those employees in particular. Do you know somebody named Drew Cantrell?
Oh, I know Control.
Did you ever see a gun in the hands of Drew Cantrell?
Yeah, a few times, mostly on the gun range, but a couple of times outside of it. I mean, I saw him I heard about one. Yeah, and I saw one too.
Let's talk about those times. Can you tell us about the times you saw Drew Cantrell with a gun on the shooting range?
Yeah, so I saw him on the shooting range. She was practicing. And I mean, I think it was clear why she was practicing, if you know what I mean.
What do you mean?
Every single time I saw her shoot, she couldn't hit the target thingy. And then sometimes it was like, wah, and she would hit someone else's target thingy. And I swear, it was like every time I saw it.
Well, Mr. Hernandez, what about the time you heard about Drew Cantrell with a gun outside of the shooting range? What happened then?
Oh, yeah. So I overheard Sky chewing out Cantrell for breaking a rule by leaving a gun loaded inside the shop area. I just can't imagine why anyone would disobey a boss. Great guy.
Well, what about the time you saw Drew Cantrell with a gun outside of the shooting range? Where was that?
Yeah, that one was in the main shop area shooting straw. Really weird.
What happened?
Oh, so I was going across the shop to leave, and I heard this ruckus behind me, so I turned around, and I saw Cantrell in an argument with another coworker. Then all of a sudden, Cantrell just raises her arm and points this gun at the other guy. I mean, it was like all the air got like sucked out of the room.
Was Skylar Coleman present when that happened?
Oh yeah, Sky was there. As soon as Cantrell pointed that gun, Sky was yelling at her to just put the gun down.
Well, I want to be very clear about something. After you saw Drew Cantrell point a gun at another person at the defendant's shop, did you continue to see her working at Shooting Star?
Yeah, I do my best to avoid Cantrell, but I still saw her there.
Thank you. Your Honor, I have no further questions.
Ross.
Yes, Your Honor. Good afternoon, Ms. Hernandez.
Good afternoon, Dole.
Now, you talked a lot about Drew Cantrell on direct examination. I want to talk about why you might be giving that testimony today. So, Ms. Hernandez, you're not very fond of Drew Cantrell.
No, I'm not.
In fact, you can't stand her.
No, you should have seen the way she treats Sky.
I appreciate that, but that was not my question. My question was, you can't stand Drew Cantrell.
No,
And you think she's smug and arrogant.
that's what I wrote in my report. You're right. I was so dramatic when I wrote that.
Now, I'd like to talk about what you can testify to in court. So you mentioned how you overheard an incident in November.
Overheard an incident in November. Yeah, you're right.
Now, you didn't see Drew Cantrell on that day, did you?
So you're talking about the gun that got brought into the shop? Am I right?
Yes.
No, I didn't see Cantrell that day.
So you can't even confirm that Drew Cantrell was at Shooting Star Gun Club?
No, I can't.
So it is your sworn testimony today that you saw Drew Cantrell on that day?
No, I overheard Sky talking to Cantrell because Sky was saying Drew.
So then you can't confirm that Drew Cantrell was at Shooting Star Gun Club on that day?
I can't because I know Sky wasn't talking to like nobody.
But you didn't see Drew Cantrell.
I didn't see Cantrell, no.
Now, I'd like to talk about whether Drew Cantrell did their job. So, on direct examination, you made it very clear that you believe Drew Cantrell is a terrible shot.
Yeah, I talked about that.
So, you only saw her shoot on two occasions.
Yeah, from those 2 occasions, you're right.
So, Ms. Hernandez, you're a gun novice.
I am. I do laser tag guns.
So that means you can't determine whether or not Ms. Cantrell was using proper form.
No,
You can't determine whether she was using that gun properly.
no.
And just to be clear, Ms. Cantrell wasn't teaching anyone at this time.
No, she was just practicing.
Now, I'd like to talk about whether Skylar Coleman did their job. Now, you said on direct, you've had a positive experience at Shooting Star Gun Club.
Oh, absolutely. I love the cafe there.
You find Skylar Coleman to be a kind and helpful person.
I do. I love her.
In fact, Skylar Coleman helped you when you're struggling to get a lease on your business.
She did. She's just so sweet.
Now, Ms. Cantrell, I'd like to talk about what you actually know about the May 28th incident. Now, you were not at Shooting Star at this time.
Is that the one in the paper?
Yes.
No, I wasn't there. I was working at laser tag. Yeah.
So that means you can't testify to Ms. Cantrell's actions.
No, I can't.
Can't testify to Ms. Cargo's actions.
No, I didn't see a car. No.
Which means you have no idea what happened at the time of the incident.
Well, I'm glad I wasn't there. So no, I didn't see any of that.
Thank you, Ms. Hernandez. No further questions.
Redirect.
No redirect, Your Honor. May this witness be excused?
Yes, thank you.
Thank you, Judge.
Okay, next witness.
Yes, Your Honor, the plaintiff calls Dr. Morgan Judd to the witness stand. And Your Honor, before we proceed, I'd ask for a time check on behalf of both parties.
The plaintiff has 41 minutes and 15 seconds remaining, and the defense has 40 minutes and 56 seconds.
May I proceed? Good afternoon. Please introduce yourself to the members of the jury.
Good afternoon, I'm Dr. Morgan Judd.
And Dr. Judd, could you tell the members of the jury what you do for a living?
I'm an associate professor at Empyrean State University, where I primarily teach and research in the area of gun violence prevention.
And how are you qualified for that position?
Well, I received my doctorate in public policy from Tulane University. And then additionally, just prior to receiving my degree, I spent almost 10 years as an investigator with the Department of Justice in the Bureau of Alcohol, Tobacco, Firearms, and Explosives. My experience is both academic and practical.
And how are you involved in today's case?
I was retained by Justice Carbo to perform an analysis of the circumstances surrounding his injury. In particular, I was asked to analyze the events leading up to the injury and to determine the cause of the injury.
Now, how does your work as a professor qualify you to analyze the causes of a firearm-related injury?
One of the most important subjects I lecture on is gun safety. Now, there's only so much that can be done to prevent crimes committed with firearms. However, almost every unintentional firearms-related injury can be easily prevented with proper gun safety. And that's exactly what I was asked to analyze in this case. Now, gun safety principles may have been violated, and the results.
Your Honor, we move to tender Dr. Judd as an expert in firearm safety under Rule 702.
Any objection?
No objections, Your Honor.
Tendered or accepted as an expert.
Yes, Your Honor. Now, Dr. Judd, in forming your conclusions in today's case, did you rely on sufficient facts and data?
Yes, sir, I did. I reviewed numerous eyewitness reports and exhibits.
And in analyzing those facts and data, did you use methods that are standard in your field?
Of course.
Now, Dr. Judd, earlier you mentioned analyzing events leading up to the injury. Could you explain what those events were?
I was asked to analyze the gun safety of Drew Cantrell, the safety instructor who was handling the firearm that shot Justice Carbo. I looked specifically at Ms. Cantrell's conduct over the months leading up to the injury to determine whether or not she was fit to safely handle the firearm.
And what did you conclude?
I concluded that Ms. Cantrell was not, it was not safe for Ms. Cantrell to safely handle the firearm.
Well, what led you to that conclusion?
Ms. Cantrell engaged in multiple inexcusable violations of gun safety leading up to the day of the injury.
What were these violations?
Ms. Cantrell was reported to have intentionally removed a loaded gun from a firing range. Now, this is a violation of a basic safety principle, which requires that all guns be unloaded prior to being.
Objection to the lack of foundation, if I may be heard on that point. Sure. Your Honor, Ms. Cantrell, Dr. Judd is testifying as to what caused the violations. They haven't specified what specific documents or eyewitness reports they used in order to come to that determination. Without laying that foundation, is testimony.
Your Honor, I believe you did lay that foundation. I asked this witness what materials that she reviewed in preparation for today's case, and she responded with all the materials that she reviewed. Witness statements, affidavits, and eyewitness accounts.
Your Honor, if I may respond, we do agree that the witness has laid that foundation into what generally Dr. Judd has reviewed. However, in coming to the specific conclusion, they haven't provided any foundation as to what specific evidence, what specific testimony they used in order for Dr. Judd to come to that conclusion.
I think I'm gonna overrule the objection. You can address that in your cross.
Yes, Your Honor.
Thank you.
Yes, Your Honor. Now, Dr. Judd, did you get a chance to finish your answer?
Not quite. As I was saying, Mr. Cantrell violated a basic rule of gun safety when he removed a loaded gun from a firing range. This is a violation of a basic safety rule, which requires that all guns be unloaded prior to being stored or transported. But this was not her most egregious violation.
Oh, what do you mean by that?
There were multiple accounts that Ms. Cantrell, in the heat of an argument, pointed a gun at a coworker.
Dr. Judd, could you explain the significance of that event in your analysis?
This behavior is an absolutely unacceptable breach of safety, even for the least experienced handler of a firearm. But for a safety instructor to show such blatant disrespect for the rules of gun safety, it's disqualifying. Ms. Cantrell should not have been handling firearms.
Now, Dr. Judd, I'd like to move to the second part of your analysis, the actual cause of the injury itself. Did you give your conclusion to the members of the jury?
Of course, I
Objection, Your
concluded.
Honor. It's an improper expert opinion, if I may be heard. Your Honor, Dr. Judd is testifying as to what caused Ms. Carbo's injury. Your Honor, they're here today as an expert in firearm safety. They can't testify as to what causation related to injury. They can only testify specifically to Ms. Campbell's conduct and whether or not it conforms to the rules of firearm safety. To testify to causation would be severely beyond their scope of expertise. And in fact, opposing counsel hasn't read under Rule 702B and C sufficient data and methodology in order for Dr. Judd to come to that specific conclusion.
Your Honor, may be heard?
Yes.
Your Honor, I believe we tendered this witness as an expert in firearm safety, and if I may make an offer of proof. Sure. This witness, I believe, will continue on to say that Drew Cantrell violated several safety rules, and that was the cause of Justice Scarborough's injury. Your Honor, we're not diving into mechanics. We're simply talking about this witness's conclusion about firearm safety violations, and those are what caused the injury. Your Honor, we are not reaching into another area of expertise.
Your Honor, it's still our belief that what Dr. Judd is going to go into is not related to Drew Cantrell's specific conduct, but as to relation to what caused particular injury. Under Rule 702, there hasn't been sufficient facts or data for the expert to come to that conclusion, as well as they haven't articulated any methodology to come to that conclusion. And if I may direct your attention to Piper versus Polke, the trier of fact is the ultimate gatekeeper of unfounded expert testimony, and the proponent of expert testimony needs to show that conclusions are based on reliable methodology. So far in this direct examination, Dr. Judd has only said that their methodology conforms to other leading experts. They haven't articulated that specific methodology. Without showing that, Your Honor, this testimony cannot move forward.
Your Honor, maybe heard to that point?
Sure.
Foundation?
Just very brief.
Yes, Your Honor. Under Rule 705, disclosing the facts or data underlying an expert's testimony. According to that rule, Your Honor, we do not need to disclose the exact details that Dr. Judd relied upon, just the general information and whether that was sufficient to come to her conclusions.
Your Honor, if I may briefly respond.
Just very briefly.
Your Honor, my objection wasn't on disclosure of facts. It's on whether or not Dr. Judd used reliable methodology. Under Piper versus Polke, they need to be able to articulate what that methodology is in order for the expert to come to a particular conclusion. It's not sufficient for the expert to just say that their analysis conform to the generally accepted standard. They need to be able to articulate that. And without being able to do so, this testimony cannot move forward.
I'm understanding you essentially are making two objections. One, about the conclusion that you think she's going to reach with respect to what happened, what caused the issue, right? And then one with respect to how she gets to that.
Yes, Your Honor.
Okay. I think what I'm going to say is I will sustain the objection with respect to articulating her methodology. If you can go into some aspects of that, we can investigate that. Obviously, you can make an objection if you don't feel like he's done that appropriately at that point in time. So I'll sustain that. With respect to the conclusion, I think I will overrule that objection again without prejudice. We'll see where she goes with it. I do think that the doctor can testify as an expert in gun safety that the either handling or mishandling of a gun resulted or did not result in the injury that happened here. To the extent the testimony goes beyond that, I think the objection would be valid. But at this time, again, I will overrule that portion of the objection without prejudice. To the extent the testimony goes there, we can address that.
Yes, Your Honor.
Yes, Your Honor.
Thank you.
Now, Dr. Judd, could you explain to the members of the jury what specific methodology you applied in your coming to your conclusion in today's case?
Absolutely. I use something called retrospective analysis, which is in basic terms where I review eyewitness accounts, affidavits, exhibits, and then I come to a conclusion based on those things.
Now, I'd like to move to the second part of your conclusion, the cause of the injury. Could you explain your conclusion to the members of the jury?
I concluded that Ms. Cantrell violated at least two basic principles of gun safety while handling the firearm that shot Ms. Carbo, and that each of these violations led directly to the injury.
I'd like to start with that first one. What was the first principle of gun safety that Drew Cantrell violated?
The first principle is stability. Now, holding a gun properly produces a stable platform. Flinching is a response to the anticipation of a gun firing. Now, the evidence showed that just prior to firing that first shot, Miss Cantrell flinched, creating a dangerous situation in which the gun redirected
Objection,
unpredictably.
Your Honor. It's an improper expert opinion. If I may differ on that point. Your Honor, the witness is going as to what factors could have caused the redirection of the gun. This is beyond the scope of expertise. It's not commenting on Miss Cantrell's conduct. It's commenting on how the specific gun was redirected and how that could happen. Again, it's a lack of personal knowledge on that point by itself. And so far as that's the point, they're commenting on causation, which is going beyond the scope of what the opposing counsel initially described, which is specific conduct. And in that case, Your Honor, it's under Rule 7.
Your Honor.
And sorry, and I'm going to direct this question at you.
Of course, Your Honor. She's been tendered as an expert in gun safety, not in gun science, I guess you would say, or gun mechanics. Okay. What would be your response to that? Absolutely, Your Honor. It's the plaintiff's belief that firearm safety covers the overarching overarching factors in gun safety and gun handling. Your Honor, for this witness to come to a conclusion in firearm safety, one must need to understand the basic principles of gun recoil and redirection. Your Honor, that is well within the scope of this witness's expertise.
Your Honor, if I may respond, under stipulation 13, our expert is an expert in firearms mechanics and analysis. There's a reason why the prior court determined that there was a distinction between firearms safety and firearms mechanics. No foundation has been laid as to how Dr. Judd is familiar with how Dr. Judd is extensively familiar with recoil and the specific mechanics of a Glock 22 firearm. It's not based on sufficient facts or data. It's not based on sufficient methodology. And so far that's the case, Rule 702 still applies.
Your Honor, I believe that there was a distinction. Both the plaintiff and the defense's expert were respectively situated in their specific lines of expertise. Your Honor, I still hold, and opposing counsel has not addressed my point, that firearm safety does include gun mechanics. It doesn't include the inner workings and physics of gun mechanics, but you do need to have a certain level of expertise of gun mechanics, and that is within the scope of this witness's expertise, Your Honor.
I'm going to sustain that objection. I think that what you're getting at, what you've been getting at for the objections is probably true. We're talking about what is gun safety and not necessarily how the gun reacts in relation to that safety. So I just ask you to keep it there.
Absolutely, Your Honor.
Yes, that would be great. Thank you.
Now, could you describe that first principle of gun safety that Drew Cantrell violated?
Sure. Now, the first principle that Miss Cantrell violated was stability. Now, when you don't hold a gun properly, a possible outcome could be a redirection of
Objection, Your Honor, on the same grounds as speculation.
I think this is within her, I'm going to overrule that. I think this is within her area of expertise with respect to how gun safety works, let's say.
Yes, Your Honor.
Thank you.
Did you get a chance to finish your answer?
not far. When you don't hold a gun properly, it can lead to severe and dangerous outcomes. And in this case, Ms. Cantrell did not handle a gun safely. Specifically, she did not have a firm or stable grip on the gun in question, which could have caused it to redirect.
Objection, Your Honor, on the redirection point.
I'll stay in that objection. I think we can, the jury can infer what it will, I will say, from whether or not there was safety being followed here. So I'll sustain your objection.
Strike.
Yes, great.
Your Honor, I just asked that the last portion of that one.
Yes,
just that the portion of the answer that remained under gun safety would be still in.
Absolutely, yes.
Yes, Your Honor. Now, Dr. J, could you explain the second violation that Drew Cantrell committed in today's case?
There's just one more point that I want to touch on as far as the principle of stability. Now, the main point in this overarching principle of stability.
I'm going to overrule that. We'll allow her to.
Yes.
Thank you.
Is that a flinch, such as Ms. Cantrell exhibited, proves a lack of training and experience in handling firearms. With that, I can move on to the second principle of gun safety that Ms. Cantrell violated.
Of course, could you explain that second principle to the members?
The second principle is control, and this is by far the most important. In fact, it would be helpful if I could step down to demonstrate this principle to the jury.
Your Honor, I'd ask that the witness be allowed to step down and make use of the demonstrative. It's been reviewed by opposing counsel.
Any objection to the use of the aid?
Your Honor, if I just may ask which particular aid opposing counsel will be using?
The one we reviewed before trial today.
Just to clarify, this is the barrel for this gun?
Yes.
Your Honor, I'm going to object on specific use of this demonstrative. While we did consent to this demonstrative existence, we believe that Dr. Judd's testimony is going to be going into gun mechanics in the specific barrel. No foundation has been laid. We've gone through the issue of application of firearm safety and firearm mechanics, and so far as that's the case, we're going to object.
I'm gonna allow the doctor to use this and testify, given the discussions that happened beforehand. There seemed to be some misunderstanding about that. I will allow the doctor to testify. And then I would just ask the same thing that I asked when the other witness was down, that we just minimize the testimony in the
Yes, Your
trial. Thank you.
Yes.
Thank you.
This is a prop I use to teach my students the principle of control. Now, if you'd imagine for a moment that this is the barrel of a gun, with the orange tip being the mouth, where the bullet exits. Now, what I'm about to show you can happen in less than a second. I'll slow it down to help demonstrate what could happen. Now, imagine for a moment that I've just fired a gun when I begin to lose control of it. I attempt to grab it, to maintain my grip on the gun. But now look where the barrel of the gun is pointing. It's pointing at me, or it could be pointing at someone else.
Objection, Your Honor. So I'm going to object to lack of personal knowledge, because the way that Dr. Judd is describing the specific gun movement with this barrel, we believe that they're trying to extend this to how the gun behaved on May 28th. It's lack of personal knowledge on that regard. Dr. Judd was not there. She can't determine how exactly the specific gun changed its orientation. It's not based on sufficient facts or data. No foundation's been laid. It's an improper activity.
Maybe to that point, go ahead. Your Honor, I'd like to make it very clear that Dr. Judd is not demonstrating the events of May 28th or the events of the actual gun in this case. As she stated before, she's demonstrating a safety principle she uses to teach her students. There's no connection between the gun in today's case and this prop gun.
I'm gonna overrule the objection only. I think you can address this on cross-examination as well. The jury can, I haven't heard her testify as to anything that happened on a particular day, as of yet, but I think the jury can draw whatever inference and the opportunity cross.
Your Honor, just on a brief point, I could amend the objection to at least a lack of foundation. Particularly that Dr. Judd hasn't shown that the way that the specific gun, whether or not a bunch of birds, whether or not the gun will behave in this specific way always, without that foundation being laid, the testimony comes.
Okay, I'm going to, just respectfully, I'm gonna overrule that, but I will watch very closely for that here now, so I.
Yes, Your Honor.
Just obviously without prejudice, I'll leave my, thank you.
You may continue, Dr. Judd.
All right. Now, after the barrel of the gun, or after losing control of the gun, I've attempted to maintain my grip. The barrel of the gun has ended up pointing at myself. Now, the worst part is, any of my fingers, or even my thumb, could end up squeezing the trigger. All because I grabbed for a gun I'd already lost control of.
Well, I'd like to clarify something. If you do lose control of the gun, what should you do?
Loosen your grip. Even let it fall to the floor. It's too easy for your grabbing fingers to accidentally squeeze the trigger, which could have disastrous consequences.
Thank you, Doctor. You may return to your seat. Now, Dr. Judd, how did Drew Cantrell violate the gun safety principle of control in today's case?
According to Ms. Cantrell's own deposition, she lost control of the gun. But instead of loosening her grasp, she attempted to maintain it, to keep on gripping that gun. And it fired again. Ms. Cantrell did the opposite of what a safe gun operator would have done.
Well, given all these safety violations you have identified, did you determine a cause for Justice Scarborough's injury?
I did. I concluded that Miss Cantrell's safety violations were the root cause. Her unstable grip caused her to lose control of the gun. And then she tried to maintain her grip on the gun.
Objection, Your Honor, to improper expert opinion.
I think we did address this earlier, right? This was the ultimate cause issue.
Yes, Your Honor, but I believe that Dr. Judd is going into specific statements about how this gun oriented itself on the May 20th accident. They've extended the safety violation towards what specifically happened on May 28th. That was my earlier objection, and you made it clear that that's what we were looking for.
Your Honor, maybe heard.
Yes.
Respectfully. Your Honor, I'd like to make it very clear that gun safety violations do have an effect on the way guns are handled, specifically how they were handled in today's case. That is well within this witness's expertise to say how gun safety violations affected the gun and ultimately justice for injury. That is well within this witness's expertise.
I am going to sustain the objection. I think this is what we discussed earlier with respect to the determination. She can provide opinion testimony as to whether or not safety was followed. What the causation was I think what you're indicating that the jury you can certainly make that argument to the jury, I would say, and they can infer from it as a finder of fact what they will. Is that
Yes, Your Honor.
okay? Okay.
Move to strike, Your Honor.
Yes, just that portion again.
Of course. Did you get a chance to finish your answer?
Not quite. Regardless of what happened before the gun fired again, Miss Cantrell did attempt to maintain her grip. And the gun fired again. Now, had either one of Miss Cantrell's safety violations not occurred, it is highly unlikely that the bullet that struck Mr. Cargo would ever have been fired.
Thank you, Your Honor. I have no further questions.
Thank you.
Cross-examination.
Cross-examination.
Good afternoon, Dr. Judd. I want to start off by talking about why you're testifying.
All right,
You're here today as an expert in firearms safety, correct?
that's correct, sir. I am.
Well, not only are you an expert, you've advocated for stricter gun control.
I'd say an advocation for gun safety laws would be a better term.
But you'd agree with me that these are stricter regulations on that, correct?
I suppose so, yes,
You'd agree with me that gun control is a highly debated subject.
absolutely.
You'd agree with me that there are many people who disagree with your views.
That's right, sir, there are.
Dr. Judd, you've never worked in a gun range, correct?
No, I haven't. I have worked extensively with firearms during my time with the ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
Just because that's none of my, they never worked in a gun range.
Not in a gun range specifically, no. I have shot in gun ranges plenty of times before though.
So you don't know what the legal requirements are regulating gun ranges.
That's incorrect, sir. I do.
It's your sworn testimony today that you know the legal standards of regulating gun ranges?
Maybe not the legal standards specifically, but I'm certainly well aware of all of the necessary safety requirements at gun ranges.
Right, but those are requirements for firearm safety. Those are not the legal requirements regulating guns, correct, Dr. Judd?
Yes, sir, I understand your question now.
No worries. Now, Dr. Judd, I want to talk to you about those 5 industry standards that you mentioned in your answer. Now, on May 28th, you believe that Drew Kitchell violated one of those industry standards. Always be aware of your target, correct?
Actually, Ms. Cantrell violated multiple of these industry standards.
Just to be clear, it's your sworn testimony today that Drew Cantrell violated multiple industry standards on May 28th?
Yes, absolutely.
Not just be aware of your target.
That's right.
All right. Now, you're aware that you made a sworn statement. You were aware that you made an expert report prior, correct?
Yes, sir,
And in that expert report, you swore to tell the whole truth.
I did.
And you're aware that as an expert in today's case, you have an ethical obligation to include all relevant details in your report.
That's right, sir, I do.
Your Honor, if I may have permission to both the closing counsel and the witness to the copy of the expert report.
Yes.
Your Honor, I'd ask to see what opposing counsel is handing my witness.
Yes.
It's a simple form.
That's it. Thank you.
Dr. Jen, this is a copy of your expert report.
It is. Looks to be,
At the back, that's your signature.
yes, sir.
Dr. Jen, excuse me. I'm gonna go over to where you talk about Drew Cantrell's involvement in the shooting accident.
All right.
So I want you to take my pen. Could you circle for me where you say that multiple industry standards were violated? Well, aside from be aware of your target.
What I'd like to do for you, sir, is actually take you back to where I highlight the 5 principles of gun safety at the beginning of the report. Number 1, we have always keep firearms unloaded except when in use. Ms. Cantrell did violate this count. Number 2, during the actual safety demonstration. Number 2 is never point a firearm at another person unless you intend to shoot them.
Dr. I appreciate that, but just to be clear, I want to talk to you about what specific violations were committed on May 28th. And that's in that, and your conclusions related to that are in the section, Drew Cantrell's involvement on the shooting accident, correct?
Yes, that's right.
Now, could you circle for me where in that section you say that multiple industry standards were violated?
I can. I just like to clear up that the 2 principles are number 2, never point a firearm at another person unless you intend to shoot them. And number 5, always be sure of a target before firing, which is 2. So I will do this circling now. Let's see.
And I'd ask opposing counsel to step away from my witness.
No worries.
Oh, here we go. Here's the section. Okay. Would you like me to read aloud the sections that I've sort of pulled out from this section of text?
Dr. Judd, I appreciate that, but I will not be asking you to read out. Nowhere do you hear you say that specifically these industry standards that you mentioned were violated, correct?
Actually, I do.
You don't say it explicitly, correct, Dr. Judd?
Counsel will just have you stand back.
No worries. You don't say it explicitly, do you, Dr. Judd?
That's incorrect, sir.
You don't say explicitly. Well, let me read out loud what you say. And I want you to read along here.
All right. I can actually see it, so maybe I could use this one. And maybe you could use it.
Well, I need to make sure.
Oh, I see.
Why don't you give her your clean copy
That-
if you can, and then
Yes.
you can read the circle copy.
You say that Ms. Cantrell flinched prior to the first demonstration, then pulled the second time. Now, just be clear, Dr. Judd.
Page in line?
Just be clear, Dr. Judd, that's not a violation of any one of those industry standards that you outlined, correct?
Could you repeat that one more time?
You stated that Ms. Cantrell flinched prior to the first demonstration, then pulled the trigger a second time. You don't specifically say that it's a violation of one of the industry standards.
That's not actually the section in which I highlight principle number 2, which is never point a gun at a person you intend to shoot. Would you like me to direct the court's attention to the place in which I do highlight this fact?
No worries, Dr. Judd, I'll take that one.
Oh.
Now, Dr. Judd, I want to approach, Commissioner approach the witness with a copy of cheat sheet, so I can enter.
I believe so.
Doctor, do you recognize this exhibit?
I do.
Can you tell me what this exhibit is?
This exhibit is a photograph of the Shooting Star Gun Club's firing range.
Your Honor, again, I'd ask that this opposing counsel step away from my witness.
Dr. Judd, you relied on this exhibit to come to the determination that Justice Carver and Nick Allred were standing too close, Ms. Cantrell?
Part of my conclusion was based on this photo. I also relied on the testimony of Mr. Allred and Mr. Carver.
now, let's talk about the positions in those images. Now, according to that fifth rule, gun user needs to have a clear unobstructed view of the target, correct?
That's correct, sir.
Now, in this position, just cover, they're behind this cantrell,
That's correct,
they're away from the line of fire,
right?
they're not in direct interference when this cantrell shot.
They, not in this specific scenario, however, it is my it is a contention of mine that Mr. Carbo did actually move.
Doctor, I appreciate that, but just to redirect it back to the question, in this position, they're not in direct interference when this cantrell shot.
No.
Thank you, Your Honor. Thank you, Dr. Judd. I have nothing to say.
Thank you. Redirect.
Absolutely, Your Honor. Now, Dr. Judd, opposing counsel challenged what you believe Drew Cantrell violated on May 28th of 2022. Could you explain what particular safety violations that Mr. Cantrell engaged in on that day?
Of course. Mr. Cantrell violated two of my standards for gun safety of note. First was his not being aware of his surroundings during the firearms instruction period. Second was pointing a gun at something that you do not intend to shoot, which is what he did in effect do.
And you also mentioned that Drew Cantrell tried to maintain his grip on the firearm. Could you explain the dangers of doing so?
Of course. If one attempts to maintain their grip on the
Objection, Your
firearm,
Honor. Beyond scope of my cross-examination. I never asked the witness about the grip or anything like that. It's beyond scope.
Maybe here. This opposing counsel directly challenged my witness as to what violations Mr. Cantrell engaged in. This witness is referring to those.
Any response to that?
Your Honor, Ms. Cantrell, Dr. Judd specifically referring to Ms. Cantrell's grip on the firearm. I never mentioned anything related to grip in cross-examination, therefore it would be beyond scope.
I think that's correct. Well, stating that objection.
Yes, Your Honor.
Yes.
Dr. Judd, could you explain how being aware of your surroundings is necessary? Was a necessary part of your conclusion?
if Miss Cantrell had been aware of her surroundings, then she might not have bumped into Miss Carbo. She might not have lost control of the gun. She might not have pulled the trigger.
Objection, speculation. Yes, Your Honor.
Did you get a chance to finish your answer?
Not quite. If Miss Cantrell had been aware of her surroundings, she might not have pulled the trigger a second time, and we might not be in court today.
Thank you, Your Honor. No further questions. Barring recross, I'd ask the excuse.
Any recross?
No recross.
Okay, yes, you may step back.
And Your Honor, with that, the plaintiff rests.
Thank you. So we will just take a brief break now. We've been set the timer for 5 minutes unless there are any objections to that.
No objections, Your Honor.
And we'll just, thank you. We'll just ask that if you see the jury in the hall, we just don't talk. Thank you. Okay. That's the beauty of being the judge. Always. Is everybody back and ready to go?
The plaintiff is ready to proceed, Your Honor.
Thank you.
The defense is ready.
All right. Defense may call their first witness.
Yes, Your Honor. The defense calls Drew Cantrell to stand. Good afternoon, Ms. Cantrell. Could you introduce yourself and your occupation to the court?
Good afternoon. My name is Drew Cantrell, and I'm an employee of specifically a firearm safety instructor at Shrewsbury.
What got you involved with working at Shrewsbury?
Well, I've been handling guns practically all my life. I used to go hunting with my father when I was little. So when I saw that Hope wanted sign at Shrewsbury Gun Club, I just knew it was a perfect place for me. So I decided to apply as a sales clerk.
Well, before you applied as a sales clerk, how many years of experience did you have handling firearms?
Well, I've been handling guns since I was a kid. And I'm 29 now, so practically probably almost two decades.
Did you receive an interview as a sales clerk, Ms. Cantrell?
I did, and it was a very extensive interview. Throughout that process, I told Skylar Coleman about my background with weapons, the fact that I managed storage back at my old job as an auto mechanic, and also told him about my work ethic and what I would bring to the shooting star gun.
Did you receive a background check during that interview?
I did. I had to fill out a Imperial State Department form to receive a background check.
Your Honor, let the record reflect on approaching opposing counsel and the witness in the exhibit. Would Your Honor like to copy that?
Sure.
Now, Ms. Cantrell, do you recognize that exhibit?
Yes, this is my criminal record.
Is it an accurate copy of that criminal record?
Yes, it is.
Your Honor, the defense introduces it to the 21 into evidence.
Any objection?
No objections, Your Honor.
All right. We accept.
Could you tell the jury a little bit more about that criminal record?
Well, they were flips in my past. They were mistakes that shouldn't have happened, but they happened. Luckily for me, my reckless driving misdemeanor doesn't affect my life.
Now, Ms. Cantrell, when did you become a firearms safety instructor?
I became a firearm safety instructor in August of 2021. One of our instructors at Shrewsbury Gun Club had quit, and I let Skylar Coleman know that I was interested in the position.
And what qualifications did you have to obtain to become a firearms instructor?
Well, first of all, I had to get my firearm safety certificate, but luckily for me, I already did that. So the next step was to obtain my firearm safety instructor certificate, which I had to do by filling out a form for the Imperial government. After Coleman saw that I was certified, she promoted.
Now, Ms. Cantor, were you reprimanded at any point while working for Shooting Star?
I was. Throughout my tenure as at Shooting Star Gun Club, I made 2 mistakes within my own work. One in May of 2021 and another one in November.
What happened in May of 2020?
Well, in May of 2021, I was still a sales clerk and I was inspecting a weapon and I was unintentionally pointing it at the shop round. Somebody thought I was pointing at them, but I wasn't. My finger was nowhere near the trigger, and the shop was empty.
To clarify, was this an intentional mistake?
No, it was unintentional.
And what position were you when you made this mistake?
I was a sales clerk.
Could you tell the jury about what happened in November of 2021?
On November of 2021, I was a firearm safety instructor at this time. I had finished teaching in a course, and I was taking my firearm from the range to the counter to empty out the magazine. But before I could do that, Skylar had intercepted me, and it was just a mistake that should have never been made.
How did Ms. Coleman respond to both these incidents?
She heavily reprimanded me on each mistake. She reminded me that these are incidents that should never happen.
Just to be clear, how did you feel about gun safety after these mistakes?
I was an advocate for it. Every time I taught my course, I made sure that I followed each rule to a T.
And did you repeat either of these mistakes after reprimandation?
Not at all.
Now, Ms. Cantor, I want to switch gears and talk about what happened on the. Now, how did you meet Justice Carbo on that?
Skylar Coleman had previously informed me that I will be teaching a safety instruction for Miss Carbo and Nick Allred. So when they came into the shop, Skylar Coleman introduced me to them and I got ready.
And what happened after that initial introduction?
Well, I grabbed the Glock 20 off the counter and I led Nick Allred and Mr. Carbo to the gun range, specifically to stall a weapon.
And just to be clear, what happened during that safety?
Well, my courses usually have 2 phases. The first phase is to go through the rules and hand my students the safety equipment, the ear protection and the eye protection. Now, the second phase is the short phase, but is as equally as important as the first phase. During this phase, I would teach them about managing and handling the gun safely and how to shoot the weapon.
Now, Ms. Cantor, you're on permission to approach the witness with a copy of 2G, which has already been entered into evidence. Your Honor, if I may have permission to publish the jury.
You may.
Now, Ms. Cantor, could you tell the jury a little bit about 2G?
So 2G shows exactly where I, Justice Carbo, and Nick Allred were standing at the beginning of the lesson.
And who placed Justice Carbo and Nick Allred in those respective positions?
I did.
And can you tell the jury why you placed Nick Allred and Justice Carbo in those positions?
So first of all, I placed them so they would be able to clearly see exactly how I was handling the weapon and shooting it. I also placed them that way for safety reasons. First timers usually flinch when they hear the first shot or in anticipation of the recoil. So I placed them to make sure if they did flinch, we wouldn't get hurt by the gun.
Where were Justice Carbo and Nick Allred before you moved to that second part of the safety demonstration?
Where I originally placed them.
And Ms. Cantor, what happened when you fired the gun?
Well, the gun had a stronger recoil than I ever felt before, but I was able to quickly manage that recoil with my hands. But at some point in the lesson, I guess Justice Carbo must have moved closer to me, and when she flinched, her left arm hit my right arm, which caused me to lose my grip on the weapon.
Your Honor, permission to approach the witness with what I've been previously entered as 2H?
Yes.
Your Honor, permission to publish to the jury?
Yes.
Ms. Cantor, do you recognize that exhibit?
Yes, 2H shows the blood splatter after the shooting.
And whose blood is that on 2H?
Justice Carbo.
Now, I want you to compare 2G and 2H, Ms. Cantor. Which position is the blood closest to?
The blood is closest to the blue X, where I understand.
Now, were you aware that Justice Carbo had moved close towards you?
No, I was not. I was paying attention to how I was aiming and firing that weapon. Safety rules, instructions, closely pay attention with how I'm handling that weapon.
Were you able to hear them?
No, as I was wearing my earmuffs, everything around me was muffled.
Thank you, Ms. Cantrell. Thank you, Your Honor. I have nothing further.
You. Press.
Yes, Your Honor, before I proceed, I request a time check.
Yes, Your Honor, the plaintiff has 30 minutes and 8 seconds remaining, and the defense has 25 minutes and 27 seconds. Yes, Your Honor.
May I proceed?
You may.
Good afternoon, Ms. Cantrell.
Good afternoon.
I want to go back to the beginning of your time working at Shooting Star. When you first started working there, you weren't yet a safety instructor, right?
No, ma'am. I started at Shooting Star Gun Club as a sales clerk.
But you wanted to be one.
Yes. Being a sales clerk didn't really satisfy me and I wanted something more.
So you got a firearms safety certificate.
Yes, with intentions of becoming a firearm safety instructor.
Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit 19. Approaching the witness at the stand. You're familiar with this?
Yes, this is my firearm safety certificate that I received from the DOJ.
And does it appear fair and accurate?
Yes, it is.
Your Honor, we move to admit Exhibit 19 of this evidence.
Objection?
Without objection.
Will be admitted.
Ms. Cantrell, and you published the jury digitally. This certificate is dated from November of 2020, right?
Yes, this is when I was first received this certificate.
But Ms. Cantrell, even after you got this firearms safety certificate, you were reprimanded twice for violating gun safety rules. Isn't that right?
Yes, but they were mistakes that I made and I was reprimanded and I never made mistakes again.
Regardless of whether you made those mistakes again, twice after you received that certificate, you were reprimanded for violating safety rules.
No, I made a mistake as a sales clerk and then I made a mistake, one more mistake as a safety instructor.
Well, Ms. Cantrell, as a safety instructor, you know the rules of gun safety, don't you?
Yes, I did.
Your Honor, I'm approaching opposing counsel with Exhibit 8. Approaching the witness at the same. You're familiar with that?
Yes, these are the gun range rules that are posted at the shooting site.
That's right. It's a list of gun safety rules that are displayed where you work.
Yes,
Objection, Your Honor, the lack of foundation. The exhibit hasn't entered the evidence yet.
I believe, I'll let you respond.
Yes, Your Honor, I'm actually laying the foundation to enter it right now. Does it appear fair and accurate?
yes, it is.
Your Honor, we move Exhibit 8 into evidence.
Any objection?
Yes, Your Honor, we're going to object to the percent, if I may be thrown that point.
Yes.
Your Honor, we believe that the statements made on the gun range safety rules are out-of-court statements being used for the future. It's on the one.
Yes, Your Honor, under Rule 801 D2D, these are statements made by the party opponent, Shooting Star Gun Club, therefore there it is.
Your Honor, with respect to party opponent, the party representative in this case would be Scott Coleman. There's no indication whether or not those statements made in those gun safety rules were made by Scott Coleman, and therefore the exception party opponent doesn't.
So I believe in the rules that for hearsay purposes, those statements are presumed to be vicariously made by the entity itself. They're responsible for it, so I'm going to hold the objection.
Yes, Your Honor.
Just to clarify, Your Honor, the exhibit submitted?
Any objection to the admission of the exhibit beyond the hearsay objection?
No objections.
Okay, so yes, we will admit that.
And the exhibit's now being displayed for the members of the jury. You say that you always follow these rules, right?
Yes, with every safety course, course I teach, I've always followed these rules.
Let's talk about how you follow them. Could you please read the second gun safety rule that's listed at Shooting Star?
Yes, it says only point at it if you want to destroy it. Always keep the gun pointed downrange and never point a gun at anything you're not planning to shoot.
Ms. Cantrell, you violated that rule just 6 months after you got that firearms safety certificate.
Are you talking about the mistake that happened in May of 2021?
Yes.
Yes, but again, that was just a misunderstanding. I wasn't actually pointing it at the woman. I was pointing it at the shop floor, but she thought I was pointing it at her.
I'm not asking about whether you think you violated that. I'm actually asking about Skylar Coleman, and Skylar Coleman reprimanded you for that incident, yes?
Yes, she did.
In fact, when the incident happened, she started screaming at you to never point a gun at another person.
Yes, and after that, I've never made that mistake.
But just 3 months later, Skylar Coleman gave you a promotion to safety instructor.
Yes, she did.
3 months after you got an official reprimand for pointing a gun at another person, You were promoted to safety instructor.
Yes, after that mistake that I made, I was promoted to a safety instructor.
Well, I want to talk about what happened just 3 months after you were promoted to safety instructor. You violated another gun safety rule.
Yes, I was carrying a weapon from the gun range to the counter to emptying the magazine, and Skylar Coleman intercepted me before I could.
Let's look at the rule. Could you please read the 5th rule that's listed as Shooting Star?
If it's loaded, leave it on the line. Check to make sure your firearm is unloaded, the action door is open, and the safety is on before bringing it to the shooting.
Ms. Cantrell, you knew about that rule in November of 2021, didn't you?
Yes, I was aware of the rule.
But you broke that rule anyway.
Yes, it was a mistake as I was going to empty it at the counter.
It's got you another official reprimand from Skylar Coleman.
Yes, and I never made that mistake again.
Well, I want to move ahead another couple of months to May 28, 2022. You were teaching a gun safety course to Justice Carbo, right?
Yes, I was.
And when you fired the gun you were demonstrating, you were unprepared for the recoil.
Yes, as it had a stronger recoil than I've ever felt before, but I was able to quickly manage the recoil.
Well, that's right, the recoil was strong. It caused your arm and Justice Carbo's arm to collide.
I did not flinch to the recoil, but Justice Carbo did flinch when she heard that first shot.
Regardless, your arms collided. Yes?
Yes, as Justice Carbo flinched and hit my right arm.
Ms. Cantrell, when your arms collided, you started to drop the gun.
Yes, I attempted to maintain my grip, but the head was just.
That's right, when the gun started to fall, you didn't just let it fall.
When Justice Carbo hit my arm, I did attempt to.
You didn't even try to relax your grip.
No, I wanted to make sure the gun stayed in my.
That's right, you tried to maintain your grip on that gun.
Correct, to prevent anything from happening.
That's when a second shot fired into Justice Carbo's leg.
Right, as the gun was falling, a second shot.
Is your testimony that the second shot did not fire when you tried to maintain your grip?
Yes, as the gun was falling, the second shot went off. I did not hit the trigger.
Is it your testimony, just to be clear, that when you tried to maintain your grip, the gun did not start to fall? The second shot did not fire, excuse me.
As the gun was falling, the second shot went off.
You made a witness statement in today's case?
Yes.
You were truthful and accurate?
Yes.
Your Honor, I'm approaching opposing counsel with this witness's statement. Approaching the witness with the same. You're familiar with this?
Yes, I am.
It's your witness statement?
Yes.
And does it appear fair and accurate?
Yes.
Ms. Cantrell, please read silently as I read aloud, directing the court's attention to page 5, lines 98 through 99. I tried to maintain my grip.
Just allow.
Apologies, Your Honor.
Opposing counsel, I think this was the case.
Page 5, lines 98 through 99. Please read along silently as I read aloud. I tried to maintain my grip, but Carbo's contact was just too hard. That's when a second shot fired and hit Carbo. Ms. Cantrell, did I read that correctly? Yes or no?
Yes, I tried to maintain the grip, and as the gun was falling, it hit Carbo.
Ms. Cantrell, what you put in your witness statement is that when you tried to maintain your grip, the second shot fired. Yes or no?
Yes, after I tried to maintain the grip, the gun fell.
Are you aware of any safety rules you may have violated when you tried to regrip that gun?
No, as I know this gun rules, and nothing violates about maintaining the grip.
Did Shooting Star ever tell you that trying to maintain your grip on a falling gun was a safety violation?
No, as it was not listed in the rules.
I'm not asking about what's listed in the rules. I'm asking about what Shooting Star told you. And they never told you that maintaining your grip on a falling gun was a safety violation. Yes or no?
Objection on ask,
Any response to that?
Yes, Your Honor. This witness isn't clearly answering my question. I'm just making this very clear to the members.
Your Honor, I believe the witness did say no to opposing counsel's question. They did answer it, and they added a bit of elaboration to contextualize the response. So far, if that's the case, is that.
Okay, we'll just narrow it in and kind of wrap it up for now. So we'll sustain that objection, but I'll allow you to.
Thank you, Ms. Cantrell. Your Honor, I have no further questions.
Okay.
Briefly, Director.
Yes.
Ms. Kendall, how did Ms. Carbo knocking you affect your control of the gun?
Carbo's grip was just so hard that it caused me to lose my grip on the gun, which caused it to fall
And when did the second shot happen?
after it fell out of my hands.
Thank you, Your Honor. Thank you, Ms. Kendall. I'm not further.
Recross, Your Honor.
Yep.
Ms. Cantrell, I want to make it very clear for the members of the jury. You tried to maintain your grip after that gun started falling, right?
Yes, but in my affidavit, I wrote that Carbo knocked my arm so hard that the gun fell out of my hands.
That's right. You said, directing the court's attention to page 5 again, lines 97 through 99. Carbo knocked my arm so hard that the gun fell out of my hands. I tried to maintain my grip, but Carbo's contact was just too hard. That's when the second shot fired and hit Carbo. Did I read that correctly?
Correct. I tried to maintain the grip before the gun fell out of my hands. But when it did, when the gun fell out of my hands, that's when the second shot went off.
Ms. Cantrell, what I read in your witness statement is that the gun started to fall and then you tried to maintain your grip, yes?
Objection, Your Honor, to ask an answer.
I'll sustain that objection.
Your Honor, may I be heard on that point?
Sure.
This witness is saying that she tried to maintain her grip and then the gun started to fall. I'm directing her to her witness statement where the order of events is different. It says that the gun started to fall and then she tried to maintain her grip. She's not answering my question.
I don't know that I agree that it says that explicitly. I think there is some ambiguity in there as to what she's saying, what you're trying to get out of that, and that's for the jury to decide at that point.
Of course, Your Honor.
Just second question.
Yes. So for the record, I will sustain that objection.
Ms. Cantrell, is it your contention that you tried to maintain your grip on a falling gun before it even started to fall out of your hands?
When Carbo hit my arm, I tried to maintain my grip on the weapon, but eventually it just ended up falling out of my hands, and that's when that second shot went off.
That's right. That's when the second shot fired.
Yes, after the gun was out of my hands, it was falling.
Thank you. Your Honor, I have no further questions.
Thank you. Anything further?
No, BB.
Okay. You may step down. All right. Defense, you can call your next witness.
Yes, Your Honor. The defense calls Jackie Stone. Good afternoon, Ms. Staub.
Good afternoon.
Could you state your full name?
My name is Jackie Staub.
And what is your occupation?
I work as a firearms and tool mark examiner for my own firm, which I established 11 years ago. Staub Examiners. My primary role is to analyze firearms, ammunition, and all related evidence in criminal investigation.
And could you tell the jury about your work experience in firearm safety?
Of course, sir.
I served as an artillery officer in the Army for 7 years to serve and protect my country, just like my father did. I'm qualified as an expert pistol shot and also have a firearms safety certificate from the Imperial government. My own firm, Staub Examiners, runs a firearms safety course, which is free of charge.
And how did you become involved in today's case?
I was retained by the Defense Council in November 2022 to provide my professional opinion and analysis on the Carbo versus Shooting Star gun club case.
And what documents did you review?
To conduct my analysis of the case, I reviewed the depositions of Skylar Coleman and Justice Carbo. I've also seen the affidavits of Nick Allred, Drew Cantrell, and Avery Union, as well as exhibits 1 through 22.
Now, from these documents, what were you asked to provide your professional opinion on?
I was asked to provide my professional opinion on 2 matters. The first being Drew Cantrell's fitness to use firearms, and the second being whether or not Drew Cantrell's conduct on May 28, 2022 adhered with industry standards.
Now, I'd like to talk about Drew Cantrell. So, what qualifications does Drew Cantrell have to be handling firearms?
Well, Drew Cantrell has a firearms safety certificate as well as a firearms certificate, both from the Imperial government, meaning Drew Cantrell knows how to safely use and possess firearms, as well as instruct courses. Moreover, they have over 2 decades of experience with firearms.
Now, I'd like to talk about the training course that was offered to Ms. Carter. So, who ran that training course?
The training course was run by Shooting Star Gun Club employee Drew Cantrell.
And what was the structure of that training course?
It was done in 2 phases. So in the first phase, Drew Cantrell actually instructed the safety procedures, when handling firearms. And during the second phase, Drew Cantrell actually demonstrated how to fire a firearm.
And could you explain to the jury what the industry standard is for actually firing the Glock 22?
Of course, sir. So when firing a handgun, such as the Glock 22, it is imperative that the operator maintain a firm grip on the handgun to better manage its recoil. The operator should also not be flinching or twitch prior to depressing the trigger.
Did Drew Cantrell flinch or twitch?
I have found that Drew Cantrell did not flinch during the incident on May 28, 2022. I've come to this conclusion after reviewing the eyewitness testimony of Avery Union. She recounted not seeing any sort of unusual movement from Drew Cantrell prior to her depressing the trigger.
And did Drew Cantrell have a firm grip on the gun?
I found that Drew Cantrell also did indeed have a firm grip on the firearm. This is from eyewitness accounts of the incident. They recount not seeing any sort of directional change from the firearm, and this indicates a firm grip.
And how important is it to have a firm grip on the firearm?
Well, to maintain a firm grip is absolutely imperative. It assures that the recoil of the said firearm is appropriately managed.
Now, if you don't believe user error caused the second shot, what do you think caused it?
As Drew Cantrell followed all industry standards on May 28th, I instead think that an overly sensitive trigger on the specific firearm used by Drew Cantrell during the training course was the cause of the second shot.
Thank you, Ms. Dog. No further questions.
Thank you. Russ.
Yes, Your Honor. Before I begin, and ask for a time check.
The plaintiff has 20 minutes and 52 seconds remaining, and the defense has 21 minutes and 28 seconds.
Thank you.
Yes.
Okay, so you're confident we're,
Yes.
okay, good.
May I proceed?
You may.
Good afternoon, Ms. Stout. I'd like to take a look at your conclusion in today's case. Now, like you said on direct, the result of the second shot was not because of Drew Cantrell flinching or losing his grip on the gun.
That is correct, sir.
But you would agree with me that flinching could affect your grip, right?
I mean, it could be a factor, yes, sir.
Is that a yes? It could affect your grip?
It has the potential to, yes, sir.
It could also affect the pointing direction of the gun.
Yes, however, that I found was not applicable in this situation, as I found that there was no directional change in the firearm prior to it being possessed.
Doctor, I'd like to take a look at why you came to that conclusion. Now, you relied on the testimony of Avery Wynn, right?
That is correct.
And like you said on direct, he said that there was not a flinch.
Yes, Avery Union recounted not seeing any sort of unusual movement from Drew Cantrell prior to her depressing report.
I'd like to be very clear for the members of the jury about his testimony. He was standing over 30 feet away.
That is correct, sir, with an unobstructed view.
Actually, Ms. Staub, he didn't have the best view, right?
That is correct, sir.
Ms. Staub, he wasn't paying close attention.
He was able to say the positioning of the three involved in the incident, as well as what he believes occurred.
Ms. Staub, that wasn't my question. My question was whether he testified that he wasn't paying close attention, and he wasn't, right?
He was not paying complete attention though.
There were two eyewitnesses who were right next to Mr. Cantrell who said they did see a flinch, right?
That is correct. However, in this case, I am looking for quality over quantity. These two witnesses that you're referring to, I assume Justice Cravo and Allred, they lack the, frankly, experience required to analyze what movement is unusual or just frankly unusual. And Avery Nguyen had the extensive amount of experience required to deem that Drew Cantrell appropriately handled the fire.
Ms. Staub, I'm not asking about Avery Nguyen or the experience of those two individuals. Those two individuals said that they did see a flinch, yes or no?
They recounted seeing movement, yes.
Ms. Staub, it doesn't take expertise to see a slight movement in someone's hands, does it?
No, it does not. I agree with you on that point. However, it does take a certain amount of expertise with firearms to come and analyze.
I'd like to take a closer look at your conclusion in today's case. Now, you would agree that your entire case rests on the fact that Drew Cantrell did not flinch. Do I have that right?
Yes, I was asked to evaluate whether or not Drew Cantrell followed industry standard. In order to determine this, I evaluated whether or not Drew Cantrell flinched.
So, like you said on direct, there was no directional change in the firearm, right?
Prior to him depressing the trigger, though.
Prior to him to pressing the trigger?
That is correct, sir.
Right, ma'am, I'd like to humor me for a minute just here. Let's look at the possibility of a flinch in today's case, all right?
Of course, sir.
Now, if Drew Cantrell did flinch, the pointing direction of the gun, it would have
Objection,
changed.
Your Honor. Speculation.
Your Honor,
You may, okay, you may.
Yes, Your Honor. The opposing counsel is asking the expert witness to testify on a scenario that could have happened. Although this expert can give their opinion on facts that are found in the documents they reviewed, asking them to testify on something that could have happened is asking them to elaborate on something that's not in the evidence and therefore is inadmissible.
Madam Speaker, to that point, now this witness is well qualified, as opposing counsel mentioned. She is qualified under firearm mechanics and firearm safety is well within her expertise. She's allowed to answer if she can do so.
You may.
My objection was not that she cannot respond, it's not in her expertise. My objection was specifically to that it's not in the facts that she was able to review from the documents and therefore would be speculation.
Can you address that portion of it?
Well, Your Honor, I believe opposing counsel is questioning the relevance of this line of questioning. If any heard of that point.
I think if I understand what you're saying, you're arguing that this goes too far afield of the actual facts of this case.
Yes, Your Honor, that's right.
Maybe heard at that point.
Sure.
Your Honor, this is extremely relevant and probative in today's case. Your Honor, it's plaintiff's belief that Drew Cantrell did flinch. And Your Honor, I'm going to outline exactly what a flinch would look like and how that perfectly aligns with the events of today's case. Your Honor, that is extremely relevant to today's case.
So,
Brief response.
very briefly.
Although it may have probative value, I believe it's delving into facts that are not explicitly said in the documents that Ms. Staub revealed, even if it has probative value. My objection was not to more prejudicial than probative.
It is a very close call. I will say I'm going to overrule the objection. The reason being that whether or not there was a flinch and when that flinch happened is absolutely material and has been argued by both sides or questioned by both sides. I think that's an issue that the jury can do. Assuming that your questioning stays narrow and relevant and within her expertise, she can provide an opinion on various hypotheticals, and you're certainly welcome to cross and discuss the relevance or irrelevance of those hypotheticals.
Yes, Your Honor.
Thank you.
So, Ms. Staub, if Drew Cantrell did flinch, the pointing direction of the gun would have changed. Do I have that right?
Sorry, I'm gonna ask you to clarify flinch prior to depressing the trigger.
Ma'am, if Drew Cantrell did flinch prior to depressing the trigger, the pointing direction would have changed, right?
I could consider that to be a possibility.
Is that a yes to my question? It could change the direction of the gun?
Yes, it could be a possibility.
Ma'am, in today's case, the pointing direction of the gun, it did change, right?
It did in fact change, however, a firm grip on that handgun makes it extremely unlikely that it was Drew Cantrell's conduct that caused this change.
I'd like to take a look at specifically a firm and stable grip. Now, you made a report in today's case, right?
That is correct, sir.
And it's your testimony before us today that Drew Cantrell maintained a firm and secure grip on the firearm, right?
That is correct, sir.
Ma'am, you were asked to prepare a report in today's case, right?
That is correct, sir.
You were truthful and accurate in that report.
That is correct.
And you had the chance to update that report up until today's trial.
That is correct.
And I'm approaching closing counsel with the copy of the citizen's report. You guys have a copy? Approach.
Tell me what lines you're.
Absolutely. Approaching the witness with the same. Now, Ms. Dodd, this is the report you made in preparation for today's case.
No, it is not. This
Damn
is
it.
Dr. Morgan Judd's reports. I've never seen this before.
Terribly sorry. I need to redirect to your report. Ma'am, this is the report you prepared for today's case.
That is correct, sir.
You were truthful and accurate in that report, right?
Yes,
Nowhere in this report do you mention that Drew Cantrell had a safe and secure grip on the firearm, yes or no? Ms. Stubb, nowhere in that report do you mention that he had a safe and secure grip on the firearm?
no, it was not.
I'd like to talk about another hypothetical. If Drew Cantrell did flinch, the recoil would have been unmanageable, right?
To a certain extent, that is possible.
But Drew Cantrell reported that the recoil in today's case was unmanageable, right?
Yes, due to an overly sensitive trigger.
Ms. Stubb, if Drew Cantrell did flinch, that would have caused a second inadvertent shot, correct?
That is a possibility. However, I firmly believe that to be unlikely in this situation. I believe instead an overly sensitive trigger that was unanticipated by Drew Cantrell was instead the cause.
Ms. Dobbs, your testimony in today's case that if Drew Cantrell didn't flinch, that it did flinch, that it wouldn't have caused him to fire the gun again?
I'm sorry, I don't quite understand the question.
Is it your testimony in court today that if Drew Cantrell did flinch, that the gun wouldn't have fired a second time?
I am saying that it is a possibility that, sorry, I quite frankly don't understand your question. Could you ask it again?
Ms. Bob, the specific verbiage in your report is that if Drew Cantrell did flinch, it would have caused a second inadvertent shot.
I say that it is a possibility, that is correct.
Ms. Dobb, if Drew Cantrell did flinch, that would have been a violation of best practices, right?
Yes, however, I am quite confident that Drew Cantrell did not flinch according to eyewitness accounts of the incident.
Objection under non-responsive, but it's a yes or no question.
I think I'm gonna leave you to control the witness.
Of course, Your Honor.
Yes.
Ms. Dobb, so I'd like to be very clear. If Drew Cantrell did flinch, that would have been a violation of best practice, yes or no?
Hypothetically, if he did flinch, that could be a violation. However, that is simply not applicable to today's scenario.
So is that a yes to my question?
Sorry, could you re-ask it?
If Drew Cantrell did flinch, that would have violated best practices.
That is true.
Thank you, Your Honor. I have no further questions.
Anything further?
Yes,
Yeah.
3-3.
Yes.
Now, Ms. Dodd, why did you believe that Ms. Cantrell did not flinch?
I firmly believe that Ms. Cantrell did not flinch as, first of all, flinching is the first thing that not flinching is the first thing that someone learns when they handle firearms. So Drew Cantrell's extensive level of experience led me to believe that she would never make such a beginner mistake. Moreover, eyewitness accounts from A.B. Nguyen recount to not seeing any sort of unusual movement from Drew Cantrell prior to her testing.
No further questions.
Will you cross, Your Honor? Yes. Ms. Dobb, I'd like to ask you one question. Mr. Nguyen wasn't paying close attention to the events of May 28, 2022.
She was there at the range for customization purposes. However, she was able to say what she believed happened at the incident.
Ms. Dobb, that wasn't my question. My question was whether he was paying close attention, and she wasn't, correct?
She was paying enough attention to recount what she thought happened. However, no, she was not fully attentive to the situation.
Thank you, Your Honor. I have no further questions. May I retrieve the witness's report?
You may, yes. Any other? Sure.
No, Your Honor.
All right, you were excused, thank you. All right, final witness.
Your Honor, before proceeding, can I request a time?
Yeah.
Your Honor, defense has 20 minutes and 58 seconds remaining, and the plaintiff has 13 minutes and 1 second. And I concur now.
Okay.
In that case, the defense called Avery Lee. May I proceed, Your Honor?
You may.
Good afternoon, Ms. Nguyen. Could you please introduce yourself to the court?
Good afternoon. My name is Avery Noonan. I moved to Korean shortly after university and I've lived here ever since. If I had to introduce myself, the one thing you should know about me is that I love hunting. It's my favorite hobby and I've been doing it ever since I was little.
Could you tell us a little bit about what you do for a living?
Well, it's not official yet, but I'm starting a podcast about gun decor. Maybe it'll be called Custom Cartridges or Pistols and I don't know. Naming isn't really my thing, but everybody thinks that guns need to be these ugly, gray things that you lug around in. I'm here to tell the world that that's just not true. I wanted to bring my favorite gun to court today. It has my initials, AN, engraved in it, in big sparkly letters. But my attorney said that probably wouldn't fit it.
Do you know why you're here today, Ms. Nguyen?
I'm here to tell you about what I saw happen at Shooting Star Gun Club on May 28th.
Let's start with your history with Shooting Star. Where in Empyrean did you buy your first gun?
Shooting Star, and I've been buying with them ever since.
What has your experience with Shooting Star been like?
Shooting Star is about as good as a gun range as you'll find. After my cousin, Mary Beth Agnes, shot herself in the foot, I've been extra careful about gun safety. But Shooting Star is on another level. They follow the protocol to a T. After Mary Beth Agnes.
Objection, Your Honor, lack of foundation.
And do you have anything further on that point or any response?
Your Honor, I can further explain it. if
Okay.
that helps. Your Honor, this witness said that Shooting Star follows proper protocol to a T. We haven't heard the foundation as to how she would know that.
Any response?
Your Honor, this witness is merely testifying to her perception of how Shooting Star follows this protocol and how she witnesses what goes on at Shooting Star every day as she testified.
Okay, I'm gonna sustain the objection. I'll just ask you to kind of step back 1 or 2 steps just to make sure that we've laid the appropriate foundation. Continue from there.
Your Honor, move to strike that testimony if proper foundation is not given.
Yes, that would be great.
Yes, Your Honor.
Ms. Nguyen, how often do you go to Shooting Star?
I'm there almost every weekend, customizing the many rifles I bought from them.
And what do you see happening at Shooting Star?
Well, there's always range safety officers walking around and correcting people of proper gun procedure and gun form. I tried to help out, but no, it always had to be the professionals.
And what precautions are taken when you go to buy a gun at Shooting Star?
Well, despite the bajillion times that I've been there, every single time they still ask for my driver's license and take it to the back room to run a background check. They also ask me if I want the safety training course, so I could probably be the one running it at this point.
Ms. Nguyen, do you use Shooting Star gun range?
Of course, I go there to unwind whenever my boyfriend Josh says something stupid.
And what safety measures are there in gun range?
Well, like I said, there's range safety officers always walking around. I tried to help them out, but they just wouldn't let me.
Do you know someone named Skylar Coleman?
Oh, Sky? Yeah, everybody knows them. They're the owner of Shoes.
How do you know Skylar Coleman?
Well, like I said, I'm at Shooting Star all the time, so I run into Skylar Coleman pretty often.
And what have you noticed about how Skylar Coleman runs Shooting Star?
Sky is so uptight about gun safety. After they took over the range, I felt so much safer there.
Do you know someone named Drew Cantrell?
Drew is one of the folks who works at Shooting Star.
Were you in Shooting Star when Justice Carver was hurt on May 28th?
Yes, I was.
Well, let's talk about whether Drew Cantrell could have predicted that incident. Were you in the gun range when Justice Carver was there?
Yeah, I was showing off my new lever action repeating rifle to my friend Cam from both of them.
Where exactly were you in the gun range?
I was at the table and chairs behind stall 3.
And where was Miss Carver?
Miss Carbo, was at stall 11.
Was anyone with Miss Carbo?
Yeah. Drew came in, they were the instructor of the safety course I later learned, and another person took the safety course with Justice Carbo. They introduced themselves as Nicole.
I want to be crystal clear for the members of the jury. Was there anything blocking or obstructing your view of stall 11?
No, there was nobody in the stalls that were in between me and stall 11.
How were the people in stall 11 standing?
Drew Cantrell was farthest to the left, Justice Carbo in the middle, and Nick Allred to the right. Although I do remember thinking that Justice Carbo was really close to Drew. Drew is honestly a stick for putting up with customers like that.
Your Honor, let the record reflect that I'm approaching opposing counsel and the witness copy of pre-entered exhibit 2G. What is this exhibit, Ms. Nguyen?
Yeah, this is exactly how they were standing.
No, Ms. Nguyen, you mentioned earlier that you noticed Ms. Carbo, excuse me, was standing extremely close to Ms. Cantrell. Did they ever move further away?
No, not before the first shot.
And what happened after Drew Cantrell fired that first shot?
Well, another shot fired, which was really weird to me because typically only one shot is fired during a safety demo.
Did you notice any movement between the first and second shot?
Well, sometime in between the two shots, I saw Justice Carbo jump and hit Drew Cantrell's arm while we were holding the gun. And after the second shot, I saw Justice Carbo fall to the floor.
How quickly did Justice Carbo fall to the floor?
Well, immediately. I mean, they've been shot.
Thank you, Ms. Nguyen. No further questions.
Prize.
Yes, Your Honor. Good afternoon. I want to start by talking about May 28th, the day you witnessed my client get shot. You were working at near stall 3 when the incident occurred, right?
Yeah, I was at my usual stall 3 working on customizing my lever action.
Drew Cantrell was working all the way down at stall 11, yes?
Yeah, they were teaching a safety course to two people who I now know as Justice Carbo and Nick Allred.
You were 30 feet away, yes or no?
Yeah, somewhere around that.
We can agree you didn't have the best view, right?
There was nobody blocking in the stalls between me and stall 11 and nothing was really in my way, but no, I didn't have the best view.
You thought it looked like Justice Carbo was crowding Drew Cantrell, yes?
Yeah, based off of what I noticed, it looked like Justice Carbo was standing really close to Drew, not even giving them room to breathe.
You weren't looking very closely, were you?
Well, I was focused on customizing my own rifle, but I did see quite a bit of what happened.
Maybe you misheard my question, Ms. Nguyen. My question was whether you were looking very closely, and you weren't, right?
No, I overheard some of the things that Drew said and some of the things that they were doing, but I didn't really have any reason to.
Ms. Nguyen, I'm gonna need you to answer with a yes or no. Can you do that?
Objection, Your Honor, to badgering. Opposing counsel isn't letting them answer the question of the asking.
Buzz.
Yes, Your Honor. I'd actually argue that this witness didn't answer my question and was non-responsive. I'm redirecting this witness back to my question so that she can answer clearly.
I'm gonna overrule that objection on badgering, but just
Of course,
keep
Your Honor.
it friendly.
So, Ms. Nguyen, you weren't looking very closely, yes or no?
No, not extremely close.
Thank you. Your Honor, nothing further. Thank
Redirect.
No redirect.
You may step down. Thank you. I believe that's the final defense witness. Is that correct?
Yes, Your Honor, defense yes.
Okay. So with that, we will take another 5-minute break and we will prepare our final or our comments and we'll go to closing argument.
Yes, Your Honor.
Thank you.
Your Honor, could we get a time check?
Sure.
Of course, Your Honor, the defense has 15 minutes and 50 seconds, and the plaintiff has 11 minutes and 43 seconds.
Your Honor, if I may ask that during my closing statement that my client could reposition themselves behind the jury so I can see time.
I don't have a problem with that as long as that's fine with you.
Yeah, that's fine with me, Your Honor.
Oh,
Your Honor, while we wait, I set up a demonstrative bundle using my opposing counsel has written.
Is that okay with you?
Yeah, let me just confirm which evidence.
There was one demonstrative.
Yes, you can respond. Oh, yes, I understand now. Yeah,
I'll just have you keep it. Yeah, turn around and on the, yeah.
I will.
Okay, thanks.
Your Honor, the 5 minutes to break is,
Everybody back here?
Yes, Your Honor.
All right. George, are we ready here? All right, we'll begin with plaintiff.
Yes, Your Honor. May it please the court.
I'm really sorry. Are you reserving time for rebuttal?
Your Honor, I'm just using any time left over after my closing argument for the rebuttal.
Okay.
No worries, Your Honor. At Shooting Star Gun Club in West Piscataway, an employee is chatting with one of her coworkers, Drew Cantrell. It's a normal conversation, just talking shop. Until things take a turn. Things suddenly become heated. And the next thing she knows, Drew Cantrell has picked up a gun and is pointing it at her head. Her blood runs cold and she freezes in place. The tension only breaks when the boss of Shooting Star comes roaring over, rebuking Cantrell for such a flagrant safety violation. And 3 months later, Drew Cantrell no longer has her position at Shooting Star. Members of the jury, it's not because she was fired, but because she was promoted to safety instructor. And now we're here at trial today because just a year later, Drew Cantrell shot my client in the leg. And the company he worked for, that same Shooting Star Gun Club, put the gun in her hands. They put a gun in the wrong hands. Members of the jury, we had the burden today to prove more likely than not that Shooting Star knew Drew Cantrell was unfit to be handling guns, but that they retained and even promoted her anyways. In doing so, we had to prove that they violated the Responsible Firearms Sales Practices Act by entrusting Ms. Cantrell with a gun. Lastly, we had to show that Shooting Star's negligence caused Justice Carbo's injury. Now today, we met that burden by showing that Shooting Star ignored Drew Cantrell's irresponsibility, and on May 28th, Drew Cantrell ignored gun safety. First, Shooting Star ignored Drew Cantrell's irresponsibility. And today you heard from Roz Hernandez, who personally witnessed Ms. Cantrell's worst incident. In the heat of an argument, she picks up a gun and points it at a coworker. And the owner of Shooting Star saw the whole thing happen. Now, the defense is going to tell you that you can't judge off of just one incident. But members of the jury, this isn't merely an incident. Drew Cantrell didn't just forget to turn the safety back on after she was finished shooting. She disregarded a rule she knew full well because she was angry. At the very least, if she wasn't fired, she shouldn't have been promoted. But Shooting Star decided that their best bet after that was to hand her a gun and send her off firing it next to the most vulnerable people in that store, those without any training. Shooting Star knew that Drew Cantrell was unfit to be handling firearms. But they retained and promoted her anyways. Because of that, they violated state law by entrusting her with a gun. But we also had to prove that Shooting Star's negligence caused Justice Carbo's injury. We showed that by proving that Drew Cantrell ignored gun safety rules on May 8th. Now, today you heard about 2 more safety violations by Drew Cantrell from that day. The first was her improper grip. Justice Carbo told you that right before firing the gun, Drew Cantrell's hands jerked, and then she lost control immediately after. Now, the defense, of course, denies this, claiming that Justice Carbo made it all up. But like they asked her on cross-examination, Justice Carbo is no safety expert. She didn't know it was a safety violation when she first reported it, so there was no reason to make it up. Shooting Star, on the other hand, well, they have every reason to deny it. And the only other testimony that backs up Ms. Cantrell comes from somebody who admitted they were 30 feet away with a bad view and who wasn't even looking very closely. But we heard about the worst safety violation of all directly from Ms. Cantrell herself. Today, she got up on the stand and told us on cross-examination that when she lost control of the gun, she tried to maintain her grip. Now, to be clear, Drew Cantrell didn't admit to this at first because she didn't know what she put in her own affidavit. She told us that the second shot fired after the gun fell out of her hands. My co-counsel had to then confront her with her own affidavit to show that the second shot fired when she maintained her grip. And even then, Drew Cantrell still wouldn't admit to it. Maybe Drew Cantrell thought that the gun fell out of her hands when she tried to maintain her grip, that the gun fired when it was in midair. But common sense tells us differently. Now, to those of us with less firearm experience, that sounds about right. Why would you want to try and maintain your grip on a gun? But that's where the testimony of our expert, Dr. Morgan Judd, becomes so important. Because she told you there's almost nothing more dangerous. She actually showed you the dangers of trying to re-grasp a gun when you're losing control of it. How easily your squeezing fingers can pull the trigger again. Maybe not all of us would have known that rule, but we surely would have expected a gun safety instructor like Miss Cantrell to know. But like you heard on cross-examination, Drew Cantrell had no idea what rule she violated. Now that actually makes sense, because neither did Shooting Star. Members of the jury, I'm screen sharing what's in evidence as Exhibit 8. I want you to take a close look at this. Now, this is a list of gun safety rules that was posted in Shooting Star. I want you to try to find one that says when losing control of your gun, loosen your grip. Members of the jury, you can't find it because it's not there. Even though Dr. Judd told you that every gun safety expert should be well aware of this rule, it's nowhere to be found on Shooting Star's own list of gun safety rules. Not only did Shooting Star fail to hire a competent safety instructor, but they couldn't even bother to properly train her on the rules. Now, Shooting Star's negligence caused Justice Carbo's injury. Members of the jury, we've heard a lot of attempts by the defense to deflect the blame, to put it on my client or even the gun itself. They went even so far to prove that Drew Cantrell had a firm and stable grip. They called an expert in gun mechanics. Who told you? I put that fact in my report. Until she looked at her report and had to admit, I didn't put that in my report. But even then, let's assume the defense is right. That maybe it was Drew Cantrell's fault Justice Carbo's fault that Drew Cantrell lost control of the gun. Maybe the gun was faulty. Drew Cantrell couldn't handle the recoil. None of that changes a thing. Because when Drew Cantrell was losing control of the gun, she broke the rules again. She grasped the trigger again. We're only here today because Drew Cantrell just wouldn't let go of that gun. So by the time the gun hit the floor, it was too late. Things often go that way, don't they? When you put it in the wrong hands, it's too late. Don't let the defendant pretend like they didn't know that. Shooting Star had a responsibility to my client. Justice Carbo was vulnerable. She couldn't do anything but blindly trust that she would be kept safe. But when Shooting Star put a gun in the wrong hands, they put Justice Carbo's safety in the wrong hands. Don't let them get away with it. Find the defendant liable for Justice Carbo's injury. Thank you.
Closing from the defense.
Yes.
And if you'd like to move over there.
Yeah, I'm going to constructive posture.
Sure.
I can do that.
I can. Yeah, I mean, Your Honor, opposing counsel, members of the jury. It's not our job to stop the epidemic. In our daily lives, we all have our roles and responsibilities. As a kid, go to school, do our chores, and get back home at a reasonable time. When we become adults, those responsibilities become profound. For example, a doctor becomes responsible For ensuring their patient's health, the police officer becomes responsible for protecting each and every one of our citizens. Their life, as you know, members of the jury, is unpredictable. It comes at us with things we aren't prepared for. Doctor can't save every patient from the unique, complicated, and unpredictable nature of their illness. Police officer can't stop a person from intervening in the line of fire. And members of the jury, on May 28th, Drew Cantrell couldn't have stopped Justice Carbo from crossing. Now, earlier today, my colleague, Mr. Zarita, told you that Shooting Star has been brought with 2 causes of action. First, the negligent hiring, retention, and supervision of Drew Cantrell, and the reckless entrustment of the gun in this case. Let's go through this chart. In order to prove their first cause of action, the Shooting Star, the plaintiff needs to show you that Shooting Star was that Drew Cantrell was unfit to be a firearms safety instructor, and that Drew Cantrell's employment was the direct and proximate cause of Justice Carbo's injury. And they need to show you that because Ms. Cantrell was unfit for the second cause of action, that Shooting Star recklessly entrusted firearms to. Now, it's important to know, members of the jury, that this burden solely lies with this table, lies with the plaintiff. They need to show to you by a preponderance of the evidence, meaning more likely than not, that all of these elements are true. Anything less than that, a hair under 50%, and you must find Shooting Star Gun Club not liable. Now, over the course of this trial, we, the defense, have proven 3 facts. Fact number 1, that Drew Cantrell was in fact fit to be a firearms safety instructor. Fact number 2, that Justice Carbo's unpredictable movement and reaction was a direct and proximate cause for their own injury. And fact number 3, that Shooting Star Gun Club never recklessly entrusted a gun to Drew Cantrell. So let's start with fact. You heard from Ms. Cantrell today that they had always been passionate about guns. You heard about their pastimes bonding and hunting with their father. And before even applying to Shooting Star Gun Club as a salesperson, they had over 20 years of experience handling weapons. You heard from them that they were hardworking and willing to learn, and Ms. Coleman appreciated their work ethic. And after 2 weeks, they got the job. Now, Ms. Coleman performed a background check on them. And Ms. Cantrell, they told you that they had a criminal record. And they didn't lie about it. They didn't try to deflect it. They took accountability for it. And members of the jury, when Ms. Cantrell was promoted to a firearms safety instructor, they had the proper requirements. They had a firearms safety certificate and a firearms instructor certificate. Certificates issued by the state of Imperial. Now, members of the jury, the plaintiff mentioned 2 incidents during the course of Ms. Cantrell's tenure in May and November of 2020. But they asked that you consider both of these incidents with the benefit of hindsight, not as they actually occurred. What Ms. Cantrell told you today is on the May 2021 incident when she was a sales clerk, that she had accidentally pointed an unloaded gun into the shop floor. This was an unintentional mistake. But immediately and swiftly, Scout Coleman verbally reprimanded them. There was no repeat incident, no repeated mistake. The same thing happened in November of 2021 when Ms. Cantrell was a firearms safety instructor. Now, again, this had nothing to do with their ability to handle weapons. It had nothing to do with their ability to teach a course. But immediately and swiftly, Skylar Coleman verbally reprimanded them. No repeated incident, no repeated mistake. That's exactly what Jackie Staub told you today, is that these isolated incidents cannot be the basis for incompetence. Members of the jury, if I had to count the amount of isolated mistakes in my life, there'd be too many to count. But the fact that Drew Cantrell only had 2 while working for Shooting Star before May 28th, 2 mistakes in 20 years of handling weapons? Members of the jury, that is not a pattern. That does not define competence. Members of the jury, it's normal to make mistakes. In fact, it's part of human nature. But what the plaintiff is telling you today is that these mistakes define Ms. Cantrell, that it defines their skills, it defines their competence. Members of the jury, on May 28th, Shooting Star Gun Club put a gun in the right hands. Members of the jury, what Ms. Cantrell told you today is that they were getting worse and worse after each instance. In fact, they were getting better and better. The plaintiff's assertion that they were getting worse is simply untrue. So let's move on to that second fact. Fact number 2 is that Justice Carbo's reaction and unpredictable movement was proximate cause for their own injury. Now, members of the jury, approximate cause cannot merely be a factor. It must be the factor that is a primary cause of connection to injury. Now, let's go over what happened on May 28th. You heard from Ms. Cantrell today, and you heard from Justice Carbo that they had come on May 28th to receive a Glock 22, a beginner handgun. On that day, they received a complimentary training course. Members of the jury, that safety course, it had 2 parts: a talk on gun safety and a short firing demonstration. Members of the jury, when Ms. Cantrell moved to that second part of the demonstration, she put Ms. Cantrell, Ms. Carbo, and Nick Oliver, they put them in positions. And you saw those positions today. You saw that Justice Carbo was placed behind Ms. Cantrell and away from the line of fire. You saw that Nick Oliver, they were placed in a separate stall away from the line of fire. And members of the jury, the plaintiff's contention that Drew Cantrell and Justice Carbo, they were placed side by side, a foot apart, it simply isn't true. Look to 2G. It isn't merely just a feet apart. It's a couple feet away. Ms. Cantrell told you that they put them at a safe but close distance so they could reasonably watch the firing demonstration. But when Justice Carbo moved, there was nothing in Ms. Cantrell's experience that could have prepared them for that. Because stopping the unpredictable isn't part of the job. Members of the jury, what you heard from Ms. Cantrell today is that they were wearing goggles and earplugs, that they were facing their target. Now, Morgan Judd, they testified that that 5th rule, always be aware of your target, was violated. But on cross-examination, they agreed that in these positions, Justice Carbo and Nick Allred are not in direct interference of the shot. And this setup during May 28th was perfectly unsafe. But what changed everything, members of the jury? What changed the causal chain that caused the May 20 accident that led to that second shot being fired into Justice Carbo's leg? It wasn't Ms. Cantrell's incompetence. In fact, it had nothing to do with Ms. Cantrell at all. It had everything to do with Justice Carbo. Their movement caused the May 28th accident. Jury, compare the blood positions. That blood, what you heard from Avery Nguyen today is that when that shot happened, that Justice Carbo, they fell down instantaneously, and then they started to bleed. That was great. Blood looked like it's in the position of where Justice Carbo was initially standing. It doesn't look like it was in the position where Drew Cantrell was. Follow the blood, follow the evidence. It'll tell you exactly what happened on May 20th. Members of the jury, you heard testimony from Ross Hernandez today that Drew Cantrell was a bad shot. But Ross Hernandez, they couldn't stand Miss Cantrell. In fact, they had it in for them. And every time they did see Miss Cantrell in the range, which was only twice, by the way, they did not know whether or not Miss Cantrell was testing a new weapon, whether or not they were trying a new technique, or whether or not they were actually teaching a fire safety course. Once again, members of the jury, isolated incidents did not define competence. Now, members of the jury, you heard from Justice Carbo themselves that they saw Miss Cantrell flinch. But they told you that they don't know what a proper flinch looks like. They don't know whether or not it was recoil or whether or not it was Miss Cantrell changing position as they were about to fire. But members of the jury, the plaintiff told you that Miss Cantrell, they started to have a firm grip on that gun. And they told you that their lawyer had to confront Miss Cantrell about whether or not they actually had a firm grip on the gun before that first shot, or whether or not the gun fell. Members of the jury, their characterization of what happened in the course of this trial simply is untrue. What Miss Cantrell testified numerous times today over the course of this trial is that they tried to control the gun. They tried to control that recoil. But members of the jury, what changed their ability to handle the gun? It wasn't due to them being incompetent. It was due to Justice Carbo bumping into them and reacting. And Miss Cantrell even warned Justice Carbo that a beginner individual could flinch in anticipation of recoil. Members of the jury, you don't even have to take Miss Cantrell's word for what happened on May 28th. You heard testimony from Avery and Nguyen today, an experienced gun user, that as Miss Cantrell was trying to fire that gun, that Justice Carbo started to dangerously crowd them. Members of the jury, Avery and Nguyen did not notice any improper practice with Miss Cantrell's ability to handle the gun. And the plaintiff, they tried to make the assertion that Miss Nguyen was in a bad place, that they did not have a proper view, that they did not have a reason to pay attention to what was happening in stall 11 until they did. Members of the jury, Miss Nguyen, they were working on their customization, but something had alerted them, something that seemed not right during the initial setup on May 28th. What they told you today, and what they told you and they noticed, was Justice Carbo dangerously crowding Miss Cantrell. And immediately after, two shots. One that fired in the general direction of the targets, and the second one that fired into Miss Cantrell's leg. Now, plaintiff had tried to impeach my witness, Jackie Staub, about how a flinch could have changed the pointing direction of the gun. But members of the jury, Miss Cantrell, even in their own assertion of what the flinch occurred during that first shot, not the second. So Miss Staub's characterization of events is completely right. Because Miss Cantrell never flinched at all during that safety demonstration. Members of the jury, the plaintiff has only brought bits and pieces of evidence to paint a narrative of incompetence. But bits and pieces are not enough. Bits and pieces are not a preponderance by the evidence. Now, nobody can deny that what happened on May 28th was an accident. When people get hurt or injured, it's normal to look for someone to blame. But members of the jury, blame is not the answer. Today, blame is not justice. Now, it may be difficult for us to separate our sympathy from Justice Carbo from what has truly happened. But our duty today, members of the jury, is to separate emotion from facts. It's not easy for us to say to a person that had they looked out for their own safety, that maybe they wouldn't have gone and turned. Members of the jury, we don't come to a courtroom to do what's easy. We come to a courtroom to do what's right. Now, in order to do what's right, we must ask what is fair, what is reasonable, and what is within our control. And members of the jury, ask yourselves this. Can Drew Cantrell control the movement of Justice Carbo? Can Drew Cantrell control the mind of Justice Carbo? Can Drew Cantrell control the reactions of Justice Carbo? Members of the jury, these things that happened on May 28th, they were unpredictable. And it was never our job to stop the unpredictability. We asked that you find Shooting Star Gun Club not liable. Thank you.
How much time for rebuttal?
The plaintiff has 2 minutes and 25 seconds for rebuttal.
I concur with that, Your Honor.
Okay, thank you. 2 minutes and 25 seconds.
Yes, Your Honor, I just asked that our timekeeper move to the witness stand so that I can see her time signals during rebuttal.
Okay. That okay with you then? Defense? Yes. Okay, thank you.
And Your Honor, ask that opposing counsel take down their demonstrative. Members of the jury, I want to discuss something that the defense opposing counsel mentioned in their closing argument. They told you that we have to consider the 2 separate violations Drew Cantrell committed in hindsight. So let's do that. Drew Cantrell points the gun at someone. It's undisputed. And a year later, Drew Cantrell not only points a gun at somebody, but shoots that person on May 28th. Drew Cantrell violates the gun safety rule as a safety instructor later in November 2021. And in May of 2022, Drew Cantrell violates a safety rule in her gun safety class by maintaining her grip, something that led directly to Miss Carbo's injury. Members of the jury, when Shooting Star witnessed those violations, what did they do? A warning? A promotion? Members of the jury, it's not hard to believe that Justice Carbo was shocked when she took a class at Shooting Star. Because Shooting Star failed to ensure Drew Cantrell was a safe instructor. Find them liable. Thank you.
All right, the case will be submitted to the jury. At this time, we'll just take a brief break to allow us to finish our score sheets. You can leave the room if you'd like, but don't be too long. We'll have comments after that. Thank you. All right, everybody can breathe. Wow. First day done. Excellent. Very well done. Excellent work. Thank you to everybody in the back who was very attentive and everything. I could see that. I know these guys are focused up here, but I can see that everybody in the back is reading for you. So that's a good thing for both of you. We will go through, just do very brief comments here. I think just introduce who you are and maybe a little bit about what you do and where you're at, and then we'll get you out of here so you can take off your shoes and do whatever you plan for Saturday.
I'll go first.
Emily, you want to go first? All right.
Hi, my name's Emily Art. I'm a recent law school graduate from University of Illinois, Chicago. Very happy I passed the bar and will be sworn in very shortly next week. Thank you. This is what I do. I work for a plaintiff's personal injury firm. This is exactly the type of case we would take. So it was great seeing everyone and your theory of the case and what you guys presented. Just generally, I think the hardest part in terms of mock trial is not getting up and talking in front of people and remembering every fact or remembering every line of a witness's statement. It's listening. You're always focused on what am I going to say next? What's the next question? Do I know what my witness, said in their witness statement? But the hardest part is truly knowing what was said and really listening to what either opposing counsel said, what your witness said. And I think for the first time in all of judging mock trial, you guys really showed an ability to listen and to respond to the questions asked by your judge and the objections made by your opposing counsel, which I think is a very, very, very difficult thing to do. And I think it's an example that you all possess these very natural instincts to say, no, that doesn't sound quite right. I think there's something in there that I can object to. So I think you should all give yourselves a pat on the back on that ability, because unfortunately, it's the one thing that I think falls flat when, you're all competing. It's really hard to do. I guess my other comment is just in terms of objections and impeachment, those are really what differentiates you at the end of the day. everyone, I think, can, go through their direct and remember what the next line of question is, but really knowing how to impeach and when to use it is a hard thing to do, because even though you know the case really well, sometimes it's not always clear to the jury what the difference in the statements are. So making sure you're very clear on, you said X here today in court, but you said Y at your deposition or in a statement. Same thing with objections. Objection battles are what wins trials at the end of the day. Not whether you win them, but whether you're able to respond. And I think you all did a really good job at that. So those are things that can always be improved on. It's hard to improve them because they are in the moment, situations and how you respond. But I think for both sides, you did a phenomenal job on everything else. And the only things that, just have the littlest nitpicky tweaking are how you handle those in court in the moment situations. You all did very well, but in terms of just general feedback, those are really the things I think you guys could practice on, although it's hard, but everything else was very well done.
Thank you.
All right, I'm Kaylin Piper. I am an attorney in Michigan. I've been practicing for 5 years. I do personal injury defense side. So you have a good balance here on your jury. I've been judging these a few years now, and it is always so hard. Like, it truly comes down to like the slightest thing between, the teams. And I sit here and I struggle. And it's even hard to come up with comments sometimes because you guys do such an excellent job. So everything that I've said in comments and that I'm going to say right now is being very nitpicky. Experts, get in, get out. I deal a lot with experts. Biases, that's what you want to show, and then get out of there. Because your experts are normal, traditionally in practice are very trained to get around your yes, no, and and the witnesses actually did that for both sides today. They want to explain more, right? And you don't want them to. So just get in, get out, and use your other witnesses. Impeaching, just be very, very, very careful with that. Both sides. You gotta be, it's a very excellent tool to use if you can do it. But you gotta be spot on. The testimony or the statement in the report has to be exactly what you want it to say or not say, and make sure that that's very, very clear. Exhibits, demonstratives, pretty good use of that. There's a balance because you don't want to overdo it, and I don't think either team overdid it, but that keeps your jury engaged, right? Eventually you kind of, okay, heard that. You want me to sit here and be like, oh yeah, like, no, this makes sense. The blood makes sense. Where everybody's placing everybody. So keep using those, emphasize those, show those to your jury as much as you can. So those are my comments. So good job, everybody.
Thank you.
Thank you.
So I'm Mitch Piper. I am also a litigator, but I do not do personal injury work. So I do general civil litigation, mostly business litigation, and some real estate litigation. So if that doesn't put you to sleep, then I don't know what, but no. So I do litigation. I do that. It's a very different style of litigation than a personal injury case or than maybe a criminal case or something like that, which you might have in mock trial. And so I enjoy the opportunity to sit up here as the presiding judge and kind of spar a little bit with you guys, have some objections and see the emotion and stuff like that. So, I did appreciate that. I know that not everybody is going to be necessarily an attorney in the long run. And I think there's a lot that you learn out of mock trial, regardless of whether you're going to law school or not, or want to be an attorney or don't. And I think, the flexibility, you don't know necessarily what way I'm going to rule, right? And I'm going to rule for somebody and they're going to be happy, and I'm going to rule for somebody and they're not, or rule against somebody and they're not going to be happy, right? You don't always know what's going to come your way, whether it's in the legal field, inside a courtroom, or elsewhere. And I think taking that with a little bit of humility and grace is just an incredible skill that you have to have. The witnesses show that as well, right? When somebody's going after them on cross-examination, taking that cross with a little bit of humility and grace, that's incredibly important. And I think everybody did that very, very well here, right? Whether or not you're gonna leave this room and go upstairs and complain about whatever incorrect ruling you're taking straight to the Supreme Court or something, right? You didn't show it on your face, okay? And a judge is sitting up here trying to make the best ruling they can with the information that's in front of them, and you just have to roll with it. I think what comes along with that at the end of the day is when you're halfway through an examination and I sustain your objection and suddenly you can't ask that question that you want to ask, right? It's knowing what story do I want to get out. Because if I just have in my head that after question number 5 comes question number 6, and suddenly you can't ask question number 6 and you're like a deer in the headlights, you need to know what story am I trying to tell? What points am I going to get to? And then you can kind of reformat and reframe where you're at. So that would be my general comment. Just a couple very brief little legal things. Again, trust the jury and trust, from a mock trial perspective, trust who's scoring you, right? And in a real life perspective, trust the jury. There were times where I could tell you guys were aiming for the mic drop moment. Here it comes. I've got this line. I'm ready to go. I've locked this witness in, and boom, suddenly I make a ruling and it's not what you expected, or it doesn't let you get to the mic drop moment. We knew where you were going, right? We know what story you're trying to tell. And so just when that happens, it's okay. For me, that doesn't affect your points, right? I know that you guys can be creative. You show that in your arguments and in your openings and closings, et cetera. And so just don't let that phase you, both in the mock trial context and then in the courtroom. Be cautious, I think, about really leaning into certain things. And there's that one statement that both of you were trying to we're trying to recharacterize as to whether the gun came out of her hand before or after, right? I'm not sure if you read that statement in its narrowest form that it says either of those things necessarily, right? And so, you want to, I think, in order to have credibility for the judges, just be cautious about how far you're leaning into things that maybe are a little more ambiguous. You have to argue it. But you can acknowledge, okay, they said this, but this is why our position is more correct. Not just, nobody said this, but not just like, they're wrong, they're lying, or they're telling you something, right? It's okay, no, the way I read this in the context and in what the witness was saying, our position should be accepted. Trust the jury, trust the judge in those types of things. And then again, the only other comment I think I would make, this was what Kaylin was saying, with expert witnesses, right? There were times you guys had great objections, you had great arguments during the objections. It makes it much more fun for me. There were times where objections, especially for experts, probably could have been more cross-examination. And that was just something that I felt there. But again, I appreciate that when I'm sitting here and I get to engage a little more with each other. So congratulations to everybody. Congratulations to the witnesses and everybody watching. And I have nothing further. If you guys have nothing further, we'll.
Good luck.
Good luck to you.
I know, maybe this is clear, like I might as well have that.